Okay, we're good.
Good afternoon, everyone. I'd like to convene the Judiciary Committee meeting for April 6, 2021. At this time, members remain in caucus, so we are going to recess the meeting subject to the conclusion of caucus, and we will announce a time in which we will reconvene. At this point, we stand in recess.
Hi, Deb. Are we in recess? Oh,
We are in recess.
okay, thank you.
Waiting for him to come back from caucus. Thank you.
We ready, Madam Administrator?
We are ready.
All right. Good afternoon, everyone. I'd like to reconvene the Judiciary Committee meeting for April 6, 2021. Any remarks from my co-chair or the ranking member?
No, sir.
Thank
All right.
you. Good afternoon.
Good afternoon. We are going to jump into our agenda. We are going to jump around a little bit today, but the first item on the agenda will be, and the first item we will take up will be Senate Bill number 888. The members should be in possession of JFS language, LCO number 6457. Can I have a motion for JFS?
So move.
And a second.
Second, my palm.
Okay, I have a motion by Senator Winfield, a second by Representative Palm. This is Senate Bill 888. It is the governor's bill on an act responsibly and equitably regulating adult use cannabis. I will admit to the members of this committee at the outset that this bill very much remains a work in progress, so to speak, as we reach towards our JF deadline. The bill before you is well over 200 pages. It is a lengthy and involved undertaking and involves issues and drafting, not just by the LCO attorneys who work with this Judiciary Committee day in and day out, but certainly also involves finance issues, regulatory issues, licensing issues, and the like. I believe the bill before us gets substantially right the criminal justice components of this bill. Certainly as a first order of business, it is this committee's cognizance as to whether this drug should be legal or not. And that is, I believe, the primary vote that we are taking as a Judiciary Committee here today, is whether to legalize cannabis or not. I would submit that that is long overdue here in the state of Connecticut for a whole host of reasons, not the least of which is that this is a drug that is widely believed to be less addictive and less harmful to the body than many other drugs that we already legalize and regulate here in the state of Connecticut, including tobacco and alcohol. On the criminal justice components of this bill, This bill retains and improves upon the language we've seen for the last couple of years on erasure of prior cannabis convictions. It puts in place what I believe to be an appropriate mechanism to deal with the issue of driving under the influence, something that is, I know, of particular interest to this committee, particularly given the fact that neighboring states are undertaking legalization. And the bill before us, and particularly the S language before us, provides appropriate protections to employers with respect to the issue of cannabis in the workplace. I believe the bill before us is further along and takes into account some of the concerns and criticisms of the bill we heard during the public hearing on licensing, equity, and revenue. But certainly there is more work to be done as this bill moves hopefully towards final passage in both chambers of the legislature before the first week of June. A couple of the highlights of the changes to the JFS language you see before us, or changes to the bill that we heard in public hearing. This revised bill before us adds legislative appointments to the Social Equity Council and gives them additional authority to make it a permanent body. The council will look at ways to make sure potential societal equitable applicants have access to get licenses, and individuals from disproportionately impacted communities can get jobs in the industry. This language before us makes clear that from beginning on July 1, 2021, through January 1, 2024, only the existing medical establishments and social equity applicants can open up cannabis establishments. This bill makes sure that cannabis establishments have a social equity plan and agree to labor peace and prevailing wage provisions. The JFS language creates an accelerator program to provide technical support, mentoring, networking, and apprenticeship opportunities for social equity applicants. It creates a workforce pipeline program to help individuals from impacted communities get jobs in the industry. It allows patients in the medical program to home grow up to 6 plants starting in May of 2022. It deals with issues of local zoning and local control of allowing the establishment of cannabis establishments in their town. As I mentioned, it provides additional employer protections, particularly for our federal defense contractors. It adds in protections for college students, and it makes sure that the revenue from, or it proposes, I should say, that the revenue generated from the sale of cannabis be spent 55% on social equity efforts, 15% to grants for prevention and recovery services, and 30% to the general fund to cover administrative costs. As I mentioned, those are proposals coming out of this committee based on the concerns and the testimony we heard at the public hearing. But certainly, this is not the end of the conversation. The bill before us, I'm sure, will see additional revision as it moves through the legislative process and its next committee of assignment. Senator Winfield.
I'm sorry, Mr. Chair, did you call me?
Yeah, did you have something to add, or?
Actually, I think you did an excellent job of defining this. And I just want to add that this is one of those bills that I think we knew from the beginning was going to have a lot of effort put into it. And that we also kind of knew that when we got to this point, wouldn't be completely baked, but that the conversation will continue after this point. There are people both in the legislature and outside the legislature who paid a lot of attention to this and have a lot of interest in the subject and have things that they want to see in this bill. And I will say, as I represented on the television this weekend, this conversation is far, far from over. And I hope that we continue this conversation by voting the bill out today so that the interest of all of those involved are represented in the conversation. And with that, I'll throw it back to you. And I think Representative Fishbone.
Thank you, Chairman Whitfield. One other thing I should just mention before I forget is certainly as we move through our legislative process, we are not oblivious to what is happening around us. And certainly just last week, New York put in place a legalization and regulatory framework. Massachusetts to our north certainly has had legalized cannabis for several years. I think what we are trying to do as we maneuver through this process is to align our legalization effort in as many respects as we can with our neighboring states. And so we continue to study what has worked and what has not worked in other locations. Representative Fishbein.
Thank you, Mr. Chairman. And I thank you for the summarization of what's before us. You know, unfortunately, at the very outset, in respect for the oath that I took as a state representative to uphold the federal and the state constitution, cannot find myself to be in support of this. The fact of the matter is we come together as the United States. And the federal constitution says that under the supremacy clause, if the federal government passes a law, that state can't invalidate it. State can't say, we don't like that particular federal law and do their own thing. That through our representative government, we send representatives to Washington to represent our interests. And if residents of our state feel that this is a proper overture, that our representatives, our senators, our congresspeople advocate for a change in the federal law. And currently this product is illegal. It's a controlled substance under federal law. You know, the existence of a medical marijuana program is really a fallacy with all due respect. One can't prescribe marijuana in Connecticut because illegal under federal law. Those that engage in the activity mostly deal in cash because placing revenue from an establishment jeopardizes the federal government stepping in and doing something about that. You know, the fact that the feds don't enforce their laws is a separate issue, separate discussion for another day. Some say, well, other states have done it. Why can't we do it too? Well, other states doing it, no court has ever found that that action was actually legal. And that's troublesome to me. I certainly am open to the conversation. And, you know, perhaps a year from now, the federal government will make this product legal under federal law. I believe the House did a few months ago and, you know, awaits the Senate perhaps taking the same action. But the fact that I swore an oath to the federal and state constitution precludes, in my opinion, my voting in favor of this bill. There are aspects that are, I think, a good thing in this bill, should the federal government say to us that it is legal for us to do this. But with that, Mr. Chairman, I just had a brief question. You mentioned that the home grow aspect of the bill that's at least presently before us, which I think is 6 plants, is only open to those that are currently authorized for the medical program. Is that, did I hear you correctly?
That's correct.
So a citizen, otherwise lawful, like Vermont, I believe, allows one who is not part of the medical program to home grow. I think Massachusetts does the same thing. That would be different here in Connecticut, should this bill in its current version pass.
Representative, at the outset, that is correct. Although I would say, I believe, as is set up under this bill, both Department of Consumer Protection will have a increased role in the legalization efforts and ongoing discussions, as will the Social Equity Council. I think the intent of this bill is to allow allow us to start to legalize, regulate through the commercial market and through the home grow of the existing medical program, and then likely to eventually expand from there to allow home grow for recreational use.
I thank you, Mr. Chairman, for that answer. And, as I conclude my remarks, I have to reiterate the displeasure that I did state at the public hearing on this bill, in the fact that nobody from Demas came to us and was willing to testify that this product is not of concern to them, which obviously the feds, it is of concern. I would have thought that those individuals that our state taxpayers pay to make those determinations, make those recommendations, to advise us on those issues, if they felt comfortable with this, would actually come to us and say so. Similarly, I had some problems with the Department of Consumer Protection on this. I found it interesting that the only individuals that appeared that testified in behalf of the concept, which is really remains unchanged by the bill that's before us, in its most part, were employees of the executive branch. Most of the individuals that came to us said, for whatever reason, they were against it. Many of them were not comfortable with the social equity aspect and how it was unclear. And I don't know that that is even massaged in the language before us today. So I find all of that troubling, but most of all, I sit here standing up for the federal Constitution. So thank you, Mr. Chairman.
Thank you, Representative. And I certainly understand your point about the concern we heard on the social equity pieces at the public hearing, as I mentioned, and I just want to reiterate this because it is an important point. We attempted in some ways to propose solutions or ways to address some of the concerns we heard through the public hearing process. I'm quite sure we have not gotten it exactly right in the bill before us, but this was our attempt to highlight some of those concerns that we heard during the public hearing and hope that the conversation around those social equity issues, which I know we all share, do get worked out as this bill moves forward, and there is a final package or final deal put together. But as I said, I think there are other committees in the legislature that have as much, if not more, cognizance over some of those social equity issues, particularly licensing and regulation than we do. Our cognizance really is on the criminal justice erasure piece. And I certainly did not hear much concern or opposition to that, because I think the language we have in here is language we've vetted through fairly well on the criminal justice aspects. So thank you, Representative. Senator Haskell.
Thank you, Mr. Chair, for all of your work on this legislation, as well as to Senator Winfield, the ranking members, and of course the executive branch. I just wanted to echo your comments. I support this legislation today under the understanding that, of course, this is a work in progress and we'll continue to see the bill evolve in the coming weeks. I did just want to say that, there are some in my community who have said we ought to legalize cannabis simply because the state is broke and we could use the revenue. That surely is not the reason that I'm voting yes. And I know it's not the reason that many members of this committee are supporting the bill today. Too often, I think our conversation about cannabis legalization, it centers around revenue. But in my mind, the benefit to legalization lies in regulation. We know that right now, too many Connecticut residents, many of our constituents purchase cannabis on an illegal market. And when they do so, they're consuming an unregulated substance that could be laced with fentanyl, and that could lead to really dangerous overdose scenarios. So there were a few things that were really important for me to see in this legislation. Advertising regulations to make sure that this product isn't marketed towards young people as cigarettes were once upon a time. I see that in line 1459. Giving law enforcement officers the tools to make sure that folks aren't driving while impaired. I see that in line 4698. Putting a cap on the THC, as we've empowered the Department of Consumer Protection to do, to make sure that this is a substance that's safe and that folks know exactly what they're consuming, which is a benefit that they do not have under our current unregulated and illegal market. I see that THC cap in line 1390. And then, of course, as you mentioned, making sure that local municipalities have the ability to decide whether or not they want to host such an establishment. Those local respect for those local zoning regulations can be found on line 3472. So while the bill isn't perfect, I'm pleased that there are components that were so important to me and to my community included in this legislation, and I plan to support it moving forward out of committee today. Thank you, Mr. Chair.
Thank you, Senator. Senator Champagne.
Thank you. I just have a couple of questions, Mr. Chairman. You talked about the revenue, and you said 55% of that revenue should go to impacted communities. Can you tell me what would make an impacted community?
Senator, it's social equity efforts, and I think that still needs to be defined out better. I think that's actually one of the issues that needs to be worked through. I will submit to you that I don't believe this committee is best addressed to answer that question. I highly suspect this bill is headed to the Finance Committee after here, and that is the committee who will work through those issues.
Okay, we keep saying this is a progress. We're working on this. We're working on this. You know, I was hoping we would have something that we could actually vote on instead of saying we're just going to continue to work on this. I also must say that I'm also disappointed that Demas was not at the public hearing and their input and the impact of marijuana on, especially those with disabilities. So that creates a problem for me. 15% goes to this grant, according to what we have here, is going to recovery efforts. Do you think that through you, Mr. Chairman, I think that's really low. You know, we're introducing and we're legalizing a drug into our system, into society. We're saying that we're going to regulate it, but really, when you look at this whole bill, it really helps out the illicit market just as much as it legalizes. And depending on what we're going to tax this at, we you know, the illegal market is not going to go away. It's still going to be there. And it actually, this bill makes it a lot easier to do so. The equity applicant. So basically, the social equity applicant is somebody who was arrested for dealing drugs in the past, marijuana in the past. Is that correct?
Not necessarily. I think that's one possible category or points in favor, but that's not the sole basis.
Point in favor. Okay. So somebody who got arrested for breaking the law, we're going to say, you know what? What we're going to do is, we know you violated the law, but we're going to reward you, and we're going to take off 50% of the fees. I think that is just wrong. And I have a big problem with that. And then, you know, throughout this whole paperwork, we just have so many other things that have issues. We've really gone overboard. And one of the other things is, I maybe I missed it because this is such a long bill. The training of police officers. Where is that money coming from? And are we going to train enough officers prior to this law going into effect?
Yeah, I believe there's both in this bill, there's 30% of the revenue going back to the general fund. I believe there's also money in the governor's budget proposal this year to take money to train up more DREs, drug recognition experts, before this law goes into effect. You know, frankly, Senator, I would submit that given both the black market here in Connecticut as well as the legalization in Massachusetts and New York on our borders, we do need more drug recognition experts, irrespective of our own legalization efforts. And I applaud the governor's office for trying to build some money into the current year budget for that. And I certainly hope that we can continue to fund those efforts through a portion of the revenue that is generated through legal sale of cannabis.
All right. As this bill stands, I cannot support it. I have way too many questions and way too many problems with different parts of this. But I guess one more question is in here it talks about that people can smoke marijuana at hotels. Part of my worry is the secondhand smoke. Are we protecting the general public who does not wish to be under the influence of marijuana from the effects? I mean, I know they can say no smoking in different areas of the hotel, but you know, when I walk into a room, is the room going to, you know, have the odor? Is when I'm out in the park anywhere, or you know, are there people going to be smoking?
Senator, can you point me to the line item? Because my understanding of this bill was that actually we update the Clean Air Act to say that you can ban the smoking of cannabis in locations where cigarette smoke and other types of smoke are currently banned. I believe what this bill allows is for folks to consume other forms of cannabis in a non-smoking form in places like a hotel. So I know, for example, I've met with elderly folks who use the medical program, and they get cannabis oil infused honey and stirred into their teas. So something like that would not be illegal to do in a hotel.
Okay. Well, like I said, I want to make sure we protect the rest of our residents here in the state that do not wish to be under the influence. And I really was hoping, like I said, that we'd get some information from the Demas Department of Public Health on their take on this, because speaking to the doctors in the area, they're having some issues with people coming out of Massachusetts under the influence and ended up in our emergency rooms. Thank you.
Thank you. Representative Quinn.
Thank you, Mr. Chairman, and I'll echo the sentiments of my colleagues that I appreciate the work that both you and Senator Winfield have been doing on this, and we'll be voting in favor of this today, understanding that this is still a work in progress. But as I've said before, I continue to have issues with the operating under the influence section. One, from a standpoint of there really not being any sort of reasonable test that can be administered by the police short of urinalysis or a blood sample at this point. And also my concern that once you have arrested someone for operating under the influence and the influence was marijuana, that the license suspension part of this is remaining the same, in that someone who's stopped for smoking marijuana while driving or being under the influence of marijuana while driving is going to have to install the alcohol interlock device in their car as part of their punishment in order to get fully restored on their license. And as I've said before, I just don't think that that is an appropriate sanction for what you have done. But again, I'll be voting in favor of this with the understanding that there are still changes to come. Thank you.
Thank you, Representative. And I want to thank you. Obviously the driving under the influence piece is one of the things that very squarely is in our cognizance as a committee. And I know you've taken a particular interest, particularly with respect to the DREs and admissibility in court and those types of issues, and changes are actually reflected in the S language because of your advocacy on this issue. And so I do want to give you a shout out for that as well. Senator Lesser.
Yes, thank you, Mr. Chairman. Just a question to the proponent. Line 3741 references 3730, 3741 in that section references the creation of a tobacco specialist. I just hadn't seen that at previous versions, and I wasn't sure. I apologize if I missed that in your summary, Mr. Chairman. I just didn't know what that language was referring to, and if the connection to the cannabis elements of this bill.
Give me the line number again, Representative or Senator.
Yeah, so there's a 3741 to 3745. Then there's also in 3730, it adds the language pertaining to tobacco specialists. Obviously, this is a bill pertaining that generally has to do with the legalization of cannabis, which is something I support. I just was curious about the inclusion of this language. I hadn't seen it previously.
Yeah, I believe this is a cleanup of the. I believe this is a cleanup of the Clean Air Act provision. It looks like tobacco specialist is defined on line 3742.
So it's your understanding, just for purposes of legislative intent, it's your understanding that this is corresponds to existing law. It's not an expansion of anything other than that.
Yeah, I believe this is a cleanup under the Clean Air Act.
Okay, thank you.
Representative Baudet.
Thank you very much, Mr. Chair. And, I as you know, I'm opposed to this legislation, and I do appreciate the hard work that obviously has gone into it. My focus has been on our kids. And so during the hearing, I was asking doctors, I think there was only one general practitioner doctor who did not admit to me that marijuana is detrimental to those under 25. He basically, as I recall from his testimony, didn't know. But every other doctor that I questioned and asked agreed that medically marijuana is not good for those under 25, certainly under 21. Now, one of my good colleagues, my senator, had mentioned that this is not about money, and he's right. This can't be about money, because this is going to cost the state money overall, not make the state money overall. And anybody who believes differently, I think, is mistaken. And all you need to do is look to Colorado and California. But in terms of overall societal costs, I do appreciate the attempt at kind of utilizing the Vermont model, having 6 plants homegrown. Again, the libertarian in me, if you could tell me that we could have marijuana for those 25 and older only, and had sufficient help for those that have become utilize it too frequently, if you will, or become addicted, and treat it like tobacco in a sense, I'd have less concerns. I'm trying to, and if I may, Mr. Chairman, if you could help me find that. I see, well, why did we limit on lines on 771? Why did we limit the convictions getting erased to 4 ounces or less?
I believe because that was the possession limit as opposed to intent to sell
Okay.
under previous law.
And so it looks as though we're trying to help those that had arrests for simple possession to give them a leg up in this legislation, back up, so to speak. Is that a fair statement?
Yeah, I think as we say this, the war on drugs did not work, that I think there's many of us, myself included, who believe this product never should have been illegal under federal law. The idea is to give an erasure and a clean slate. I know we discussed this topic yesterday too. To some extent, there's some overlap, but to give a fresh start when it comes to housing and to employment and any number of other things because of a prior cannabis conviction.
And that is a part of this that I agree with. I will say what I don't understand and I can't understand is section 18 on line 1013 through 1026. How on God's green earth is it okay, reasonable suspicion for alcohol, to smell it on someone's breath when you pull them over, that you can't have someone come out and do the test if you smell marijuana? What help me out on that one. What's the logic behind not allowing the smell of marijuana to be reasonable suspicion for driving while impaired?
Representative, I think we heard quite a bit of testimony during the public hearing on this. Somebody just having the smell of marijuana on them because they were at a friend's house or they were someplace else where they got the smell on their clothes, as opposed to smoke billowing out of the car, which would be reasonable suspicion under this bill. I think it depends on the circumstances.
But if I spill if a friend of mine douses plays beer pong and gets soaking wet with beer but doesn't drink any of it, and he gets into the car next to me, I'm driving, and the car reeks of beer, that's reasonable suspicion to get me out of the car, even though I'm not the one reeking of beer, correct?
I'm not sure that it does, without kind of blurry eyes and some other rationale for pulling you over. I don't know that it does or it doesn't.
Well, I will just say from the hearing testimony, I asked a police officer, I think that a similar question, and the smell of alcohol emanating from a car is reasonable suspicion enough to bring the driver out of the car and have him do some tests. But look, so I'm hopeful that that presumably you've got the votes and this will get out. To the extent, I hesitate in saying I don't think there's any way I could vote for this legalization unless we made it 25 and over and somehow increase the ways to prevent minors from getting it. But let me go on to section 19.
Representative, let me just say on that, I made this representation at the public hearing, and I'll make it here again, that certainly this committee has tackled some of the meatiest issues again this year, as we always do, and we are always willing to hear voices from the minority party. I suspect this bill will get out on a fairly party line vote today, and that is unfortunate. I would love to have Republican support for this bill and Republican voices in the room as we get to a final package. If you or other members of this committee or the legislature, have a path to getting to yes on this bill, please give me a call.
Thank you, and you always have been receptive to my phone calls, and I do appreciate that, Mr. Chairman. Truly. As I understand section 19 for schools, the basic idea here is that you're going to equate pot to alcohol, and that so school districts have to create a similar policy for pot as they do with alcohol. Is that a fair summary of that section 19?
That's my understanding.
The issue I have there is, when kids are trying to sell alcohol, I mean, there's not a whole lot of sales of alcohol going on in schools. And I think there are sales of marijuana going on in schools that we need to address more particularly because it's easier to hide and sell. But
and I hope you're right, Representative. I hope that after this bill passes and folks can buy cannabis legally, and that we put 15% of the revenue into prevention efforts, they won't see nearly as much secondhand sale of cannabis in schools. I think that's one of the, hopeful benefits of passage of this legislation.
Well, I appreciate that, but unfortunately, people under 21 are never going to be legal to buy, and so they're always going to be buying on the black market. And I think what we saw in Colorado and California and Oregon, there was actually an increase in black market sales, not a decrease, because the black market is always cheaper. And so what you're going to see here, in my humble opinion, access is going to increase for our minors because parents are going to be doing it and they're going to be seeing it. So there's going to be, I think everybody agrees, and nobody disputed this in the hearing, that access will increase. And where access increases, use increases. And youth will never be allowed to buy in the state sanctioned stores. So they're always going to be buying on the black market. And so I guess my just one question along those lines. I don't know is there going to be a state stamp? I'm sorry, I did not get through all 6,539 lines of this legislation, and shame on me. I just didn't have time to get through all of it. But is there some state stamp that's going to be placed on the marijuana so that if it's seen out in public, that we'll know that bag of marijuana was sold legitimately?
No, I don't think there's a state stamp. Just as now there is, someone could purchase marijuana in Massachusetts and bring it back into Connecticut.
So, I mean, when we say that it's going to be safer, I just don't buy it, because I think you're going to see the illicit black market, just like it did in other states, increase, not decrease. And the kids are never going to be able to buy in the state sanctioned dispensaries. On line 1207, does that mirror bar restaurants? In other words, you could be 18 and work in a bar restaurant, but you can't, I believe you can't serve until you're 21, be a bartender or server. Is this meant to mirror bar restaurant age limits?
I believe so, yes. And I believe we heard testimony at the public hearing on that.
And so if I'm 18 years old, can I actually be selling marijuana, or do I have to be working in the back room, stocking and doing things like that? Or can I actually be in front passing out the marijuana to customers as they come in?
Representative, like you said, kind of similar to the bar example, my understanding is they can hold any job, just like somebody who's 18 can be either a busboy or a waitress in a restaurant.
But an 18-year-old can't be a bartender. So I guess my question is, can an 18-year-old be a dispenser of marijuana?
Under this language, I believe so.
So I would just ask that to be reconsidered, and of course I will follow up with you. What is presumably the intent of lines 12, 24, section 25 is to address the concerns that Attorney Fishbein or Representative Fishbein had brought up about the fact that it's illegal under federal law. This section 25 is to basically make it legal in Connecticut despite that federal law, correct?
That's correct.
I'm not gonna, well, let me just get through a couple of other issues that I really felt strongly about in the hearing. The limit of the THC content on section 32. I see that the edible component is limited to 5 milligrams. How did we come up with the 5 milligrams?
Representative O'Day, I think this was the governor's proposal. This is language that has not been changed since we saw the governor's proposal. I believe we heard testimony at the hearing that it was looking at the other states that have legalized throughout the United States, and most particularly our neighboring states.
So this is meant to be consistent with Mass and New York, essentially. I guess, as has been brought up a number of times, if you look, is there any limit to THC content in non-edibles? The reason I asked that open-ended question is I see that if you can't delineate on the product how many milligrams are on the product, then it's limited to 5. But if you can delineate the amount of THC content, is there any limit?
Representative, I'm not an expert on THC content limits. Frankly, I think I do understand that under this bill, retailers and hybrid retailers are to make their best efforts to provide low dose THC products, including products that have 1 milligram and 2.5 milligrams of THC per dose. And so I think there will be a range of products offered, and my understanding is it will be the intent is for the products to be well marked, similar to how when you walk into a package store and you pick up a bottle off a shelf, the alcohol content or the proof is fairly prominently displayed on the bottle.
And I appreciate that. And I was just looking for that line number where it says that the dealers or the dispensaries have to offer low THC content. I think
Line 1449.
Okay, thank you. So, and I had my notes here. I put why, and so I think I know the answer. But the good chair, why is it that we want to offer 1 and 2.5 milligrams of THC per dose type products?
As I indicated, I think certainly different individuals have different tolerances, and different preferences. And so similar to, some folks like walking into the package store and buying bourbon, and others like buying light beer.
Well, my understanding is because we all agree that the THC content, the higher, the more of an effect it has on someone. Than the old school marijuana that our parents tried in the 60s and 70s had a THC content of 1 to 3, and the stuff that they're doing now and creating now has a lot higher content, which can be very dangerous, particularly kids. So I see line right above that, 1434 to 1436. We need to restrict forms of cannabis products and cannabis product delivery systems to ensure consumer safety and deter public health concerns. As been said earlier, the fact that we didn't hear from anyone from the Department of Health is extremely disconcerting and upsetting to me and many of my constituents. I don't understand why we have not had input from Department of Health. It's very upsetting. I know the good chair would never, I know this is not intentional by him or them, but the fact that we didn't hear from Department of Health is just very, very upsetting. And in line 1440, we need to prohibit product types that appeal to children. We need to do more, in my humble opinion, to prevent kids from having increased access to marijuana. This is going to increase their access. I think we need to do more education. As I said during the public hearing, I've yet to meet a 50-year-old person who said, "Thank goodness I started smoking pot when I was in my teens." That person doesn't exist in my humble opinion. But I've never met them. So in line 1503 through 1509, I understand that this is kind of a warning. I would ask that we consider, based on medical experts, that we include the warning to say that doctors also advise those under 25, not just 21, but 25, not use cannabis, because I think that was the medical testimony. Look, I've got a lot more questions. Based on the fact that the good chairs I know are amenable to input, even if it's extremely unlikely I'm going to vote for this, I'm going to stop because I could go for a lot longer. And I know I already owe the whole group here a pizza party, and I don't know if I can afford 2 of those. So I would just ask that we think about the kids and how we work harder at preventing the increased access for the children. And because again, if you told me that we could wave a magic wand and make this 25 and older and not increase the use by kids, I'd probably vote for it. So thank you very much, Mr. Chair. And I just pray that I don't have to ask 20 hours worth of questions of you on the floor of the House. Thank you.
Thank you, Representative. Like I said, you have my number. Feel free to call, but I will wear comfy shoes. Representative Beach.
Yes, Mr. Chair. I just want to mention quite a few things that have already been said by my fellow colleagues, but I am certainly opposed to this legislation for several different reasons. One of which is this THC level. And if I recall correctly, during our hearings, it's about 100% stronger than the THC levels of perhaps some of us in the days of the 60s and 70s. Correct me if I'm wrong in stating that. Is there a comparison that we're using with this cultivated product? You, Mr. Chair?
Ma'am, I do not know what whether THC level is higher or lower. As I indicated, my understanding is there'll be a range of products offered, and consumers can purchase the product that they think is appropriate for them.
Okay, so we're going to have not just light beer now. We're going to have a low joint, if you will, or a low quarter ounce or whatever the case may be. In addition to those THC levels, which I have a huge issue with, there's no testing available currently, and I'm not sure how they're going to approach this. But you know, let's face it, you are in an altered state when using alcohol or any type of drug, particularly marijuana. I don't know if you've been through or by a vehicle that just the smoke is bellowing out of the windows and you can smell it 3 or 4 cars up. I have a huge issue with those people being under the influence and jeopardizing other people that are on the road and driving, including my daughters, if you will, my soon-to-be granddaughter. It's an altered state. They are impaired while driving, and there is no way for us to test. In addition to that, you know, if there's a DUI checkpoint, we're not even giving the police officers adequate tools, if you will, to give them a reason of suspicion just by smelling it. if they smell alcohol, they're able to take a look at what's happening in that vehicle. But if the car smells like weed, we can't do that. Not to mention the testing, like I said. I don't know what kind of message we're sending to our children that this is okay and that it's okay to sell weed, to partake in it. I have a huge concern. It is definitely going to cost the state more to pass legislation like this. We've seen that over to our neighbors to the west. The social services that are going to have to be offered as a result of legalizing something like this, it's critical. It's critical. The other issues that I had were, the possession issues. Now, if it's under a pound, what is it, 16 ounces? Can you just maybe give me a little bit more information on that? Because again, this is a huge bill and I tried to get through it, but I am not an attorney. And I had some difficulty getting through a lot of this.
My understanding is the limit is under the substitute bill before us is 1.5 ounces on one's person or 5 ounces locked up in a home.
Wow, 5 ounces. Back in the day, that was called a dealer. I don't know what it's called now, but I guess that's what they're calling it. Well, with that being said, I will not be voting on this. I will be voting no. Thank you. To you, Mr. Chair.
Thank you, Representative Veach. Further questions or comments from the committee? Are there further questions or comments from the committee? Senator Winfield?
Mr. Chair, I just want to echo your sentiment that I am open to conversation. I think the members of the committee know that. I think whether we are voting for a bill or not, our input is useful to whatever ultimately happens. I want to say that in my experience, there's no perfect bill, and this certainly is amongst that crowd of bills that aren't perfect. I know it was represented that people came to us talking about what we on that day talked about as the other bill, as a bill they wanted to see us do as opposed to this. But what they wanted to see us do, importantly, is what the threshold question before this committee is legalized cannabis. I am a proponent of legalizing cannabis, and I'm signed on to that other bill as well. And here I am today in support of Senate Bill 888 because we need a bill that passes through the Judiciary Committee that answers the question of legalization. And I think that if you are thinking that you want to do the equity pieces, then you need to have a legalized cannabis scheme here in the state of Connecticut. And I think that's important for us to remember. And I just want to say this. We don't get to this moment where THC levels are what they are without having experienced the moment when we started a war on drugs in the way that we started it, targeting the communities that we targeted. And when we finish with that war on drugs, we shouldn't think about the fact that we targeted those communities. And that's not just conjecture as we sometimes see it, but that's been admitted to. And if we ignore that, then we've not done our due diligence. And I think what we're doing between this bill, that other bill, and the conversation that is to come is trying to reckon with all of those things and deal with the realities in front of us. And I just want to thank everybody for their input, whether they are for or against the bill, because I think it makes us able to find ourselves in a position that is better for the state of Connecticut. Thank you.
Thank you, Senator. And certainly I echo your comments as we wrap up. Oh, Representative Filiorello with a late hand.
Oh, sorry, I apologize for the late hand. I just wanted to add to the conversation on this bill that looking at lines 117 to 126, which is the new equity language and the equity council that's been added to the governor's bill. When you read the words, means, efforts, regulations, and policies intended to identify and remedy past and present patterns of discrimination based on race, ethnicity, gender, sexual orientation. And then B, ensure that patterns of discrimination and disparity, whether intentional or unintentional, are neither reinforced nor perpetuated. And then C, prevent the emergence or persistence of foreseeable future patterns of discrimination or disparities of race, ethnicity, gender, and sexual orientation. I understand a desire to legalize marijuana, but this kind of language, I don't know that this is the proper role of government. I don't know how. We will always have disparities in the world. I don't know how legislation can identify remedy. I don't know how it ensures that patterns, intentional, unintentional, are neither reinforced nor perpetuated. And I don't know how it prevents the emergence or persistence of discrimination and disparities. I think that that is a state of the world. Nothing is equal. I find this kind of language in many, many bills coming before the body very problematic. Bills can't do this. It's not possible. If we want to legalize marijuana, then legalize marijuana. But this aspiration is misguided, and it's something that we can speak about. I don't know how you legislate equality, equity, and expect the laws to do all this. That's my only comment. Thank you, Mr. Chair.
Representative, with due respect, I couldn't disagree with you more. I think it absolutely is the role of government to try to remedy past discrimination, to try to deal with, certainly particularly with respect to this product, something that there's a fairly well documented history was made illegal and the name changed for a clearly racial animus by the federal government. And we should be providing an equitable footing for all of our citizens in the state of Connecticut, or at least doing all that we can in our role to do that. And frankly, that is one of the reasons I stand firmly in support of the effort to end prohibition of cannabis, is to right some of those historical wrongs. So I would just be remiss if I didn't take the opportunity just to, in the strongest possible terms, and folks know I don't normally do this on this committee, but I cannot associate myself with the remarks you just made.
Okay.
Further questions or comments on this bill? Further questions or comments on this bill? If there are not, Madam Administrator, please call the roll.
That was Senate Bill 888, JFS, proposed substitute LCO 6457. Senator Winfield.
Senator Winfield in the affirmative.
Winfield has voted in the affirmative. Representative Staffstrom.
Representative Staffstrom votes in the affirmative.
Representative Staffstrom has voted in the affirmative. Senator Kasser.
Senator Kasser regrets to vote no.
Senator Kasser has voted no. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel. Representative Fishbein.
Representative Fishbein votes no.
Representative Fishbein has voted no. Senator Anwar.
Senator Anwar votes no.
Could you please repeat, Senator Anwar?
Sure. Senator Anwar votes no.
Perfect. Thank you so much, Senator Anwar. Senator Bradley. Representative Callahan.
Representative Callahan votes no.
Representative Callahan has voted no. Senator Champagne.
Senator Champagne votes no.
Senator Champagne has voted no. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry. Representative Dillon.
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative DeMassa.
Representative Demassa votes yes.
Representative Demassa has voted yes. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes no.
Representative Dubitsky has voted no. Representative Fiorello.
Representative Fiorello votes no.
Representative Fiorello has voted no. Senator Flexer.
Senator Flexer votes yes.
Could you please repeat, Senator Flexer?
Senator Flexer votes yes.
Thank you, Senator Flexer. Representative Fox.
Representative Fox votes no.
Could you please repeat, Representative?
Representative Fox votes no.
Thank you, Representative Fox. Representative Gilchrist.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
Representative Godfrey votes yes.
Representative Godfrey has voted yes. Representative Harding.
Representative Harding votes no.
Representative Harding has voted no. Senator Haskell.
Senator Haskell votes yes.
Senator Haskell has voted yes. Representative Howard.
Representative Howard votes no.
Representative Howard has voted no. Representative Labriola.
Representative Labriola votes no.
Representative Labriola has voted no. Senator Lesser.
Senator Lesser in the affirmative.
Senator Lesser has voted in the affirmative. Representative Luxembourg. Representative O'Day.
Representative O'Day votes no.
Representative O'Day has voted no. Representative Palm. Representative Palm votes yes. Representative Palm has voted yes. Representative Pavlak D'Amato. Pavlak D'Amato votes no. Representative Pavlak D'Amato has voted no. Representative Porter. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rabimbis.
Representative Rabimbis votes no.
Could you please repeat, Representative Rabimbis?
Representative Rabimbis votes no.
Representative Rabimbis has voted no. Thank you. Representative Riley.
Representative Riley votes yes.
Representative Riley has voted yes. Senator Sampson. Representative Sims.
Representative Sims votes in the affirmative.
Representative Sims has voted in the affirmative. Representative Veach.
Representative Beach votes no.
Representative Veach has voted no. Representative Walker. Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Thank you, Madam Administrator. We will hold the votes open until 5 o'clock or half an hour after the end of our meeting, whichever is early, whichever is later. 5 o'clock or half an hour after the end of the meeting, whichever is later. We're certainly hoping it's 5 o'clock. All right. Next up, we will move on to item number 4 on our agenda, House Bill number 6355, an act concerning risk protection orders for warrants. The committee should be in possession of substitute language, LCO number 6462. I will entertain a motion for JFS.
So move.
And a second. I got a motion.
Second.
I got a motion from okay. I got a motion from Senator Winfield, a second from Representative Blumenthal. At all. This bill before us is a comprehensive update to the what's sometimes called the red flag or risk protection order statute, which was originally passed by this legislature back in the 1990s in the wake of the Connecticut lottery shooting. We were the first state in the country to undertake an effort to say that when someone is a imminent risk of danger to themselves or others, there should be a legal procedure, a civil procedure in many respects, to allow those guns to be removed from that volatile situation. That law has been well documented by studies by Duke University and others. to have prevented hundreds of deaths in our state, predominantly by preventing suicides. The current bill before us, as I said, updates that statute from the 1990s. Since Connecticut undertook its right of this legislation, about 12 to 15 other states have passed laws in this area and have gone significantly further than where the original Connecticut bill has. And we've seen exposed some of the weaknesses in our bill. The bill before us changes the 1999 statute by first allowing a risk protection order to enter where an individual does not have a gun. So under existing law, the order can only enter if someone already has firearms in their possession or home. This would allow for a police officer, for two police officers or a state's attorney to apply for an order to prevent someone from acquiring a firearm. This bill also allows a process whereby family members and medical professionals can petition for the risk protection order. Certainly someone living with an individual or their medical provider may have much better firsthand knowledge as to when someone is in imminent risk of harm to themselves or others than a police officer or a state's attorney does. So this allows the first application to be made by those individuals and then handed off to a police officer to do a follow-up investigation. This bill also allows for the time by which the order remains in place to be longer than a year. Under existing law, no matter the circumstances, the risk protection order expires at the end of 1 year. This allows for an extension of that year, and conversely also allows someone to petition to get their firearms back in under a year if they can show by a preponderance of the evidence that they are no longer in imminent risk of harm to themselves or others. The bill also makes other technical and conforming changes based on the passage of time since the statute was originally put in place. But those are the major changes. Representative Howard with a question.
Thank you, Mr. Chairman. I'll just, for my colleagues, I've invoked 2938C in my career on numerous occasions. I've penned, I don't even know how many imminent risk orders, seized many firearms, and also given those firearms back after a year, which to the good chair's point, with no process over those 12 months is sometimes disconcerting. And it's, you know, I think that part of legislation has viability. Knowing what I know in my experience on this particular topic and how swiftly that I and my colleagues in my area work on reports relevant to this, it was very alarming and concerning to me the issues that I heard in public hearing, and specifically incidents that may have led to this piece of legislation. So to that end, I have a few concerns as the language sits before us. And one of the underlying concerns is I think that we've created a pathway that sort of circumvents, inadvertently, circumvents the police officer's access to 17A503, which will allow the underlying individual to or have them go to the hospital for an evaluation. I certainly don't represent that this legislation prohibits that. What I'm saying is that the legislation perhaps may create in practical application a skip of that step inadvertently. So to that end, as it sits, I do have to vote no to it today, but I wanted to make a commitment to you that I look forward to the opportunity to discuss this further and achieve the goal, which I think is very achievable. And just with a little bit of consideration of the practical application based on my experience. So I'll publicly commit to you, Mr. Chairman, that I look forward to being able to do that, but I unfortunately have to vote no as the language sits today out of those concerns. Thank you.
Thank you, Representative Howard, and I look forward to your call. Representative Baudet.
Thank you, Mr. Chair. You know what, in speaking with Representative Howard privately, I do have concerns about the bill. I'm going to vote for it to get it out of committee in the hopes that both Representative Howard and I can work with you towards fixing his concerns. I don't have anywhere near the practical experience that he does on this issue. So, and I know the good chairs are always amenable to listening. So I'm looking forward to that discussion. So while I'm voting yes to get out of committee, unless Representative Howard's concerns are addressed, I just reserve my right to vote no on the floor if those concerns aren't addressed. So thank you very much, Mr. Chair.
Thank you, Representative. And I know you and I have worked on gun legislation together in the past that has received bipartisan support coming out of the House of Representatives. And I certainly hope that we get there on this piece of legislation as well. Further questions or comments from the committee? Further questions or comments? Representative Fiorello?
Thank you, Mr. Chair. I just wanted to add that in listening to Representative Howard and also reaching out to police chiefs and police officers in my district, I want to wait to see what the final bill will say, but I will be voting no as well. Thank you.
Thank you. Further questions or comments on the bill before us? Further questions or comments? If not, I want to give a brief shout out to certainly Vice Chairman Blumenthal, as well as Adam Scavera from the House Democrats Policy Office and Zoe Gluck for their efforts on this. I also would be remiss if I didn't mention that certainly during the public hearing on this bill, we heard some technical concerns from the Chief State's Attorney's Office, as well as the judicial branch. And I want to thank them for working collaboratively with us over the last particularly few days and even over the Easter weekend to refine and craft the substitute language we have before us to make this bill even stronger and probably more user-friendly than the original bill we heard in public hearing. Madam Administrator?
That was HB 6355, and it's a joint favorable substitute. LCO number 6462. Senator Winfield.
Senator Winfield in the affirmative.
Senator Winfield has voted in the affirmative. Representative Staffstrom.
Representative Staffstrom in the affirmative.
Representative Staffstrom has voted in the affirmative. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel. Representative Fishbein.
Representative Fishbein votes no.
Representative Fishbein has voted no. Senator Anwar.
Senator Anwar votes yes.
Senator Anwar has voted yes. Senator Bradley. Representative Callahan.
Representative Callahan votes no.
Representative Callahan has voted no. Senator Champagne.
Senator Champagne votes no.
Senator Champagne votes no. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry. Representative Dillon.
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative DeMassa.
Representative DeMassa votes yes.
Could you please repeat?
Representative DeMassa votes yes.
Thank you, Representative DeMassa. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes no.
Representative Dubitsky has voted no. Representative Fiorello.
Representative Fiorello votes no.
Representative Fiorello votes no. Senator Flexer.
Senator Flexer votes yes.
Could you please repeat? We saw you, but we didn't hear you.
Senator Flexer votes yes.
Thank you, Senator Flexer. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey. Representative Harding. Senator Haskell.
Senator Haskell votes yes.
Senator Haskell has voted yes. Representative Howard.
Representative Howard votes no.
Representative Howard has voted no. Representative Labriola.
Representative Labriola votes no.
Representative Labriola has voted no. Senator Lesser.
Senator Lesser votes yes.
Could you please repeat?
Senator Lesser in the affirmative.
Senator Lesser has voted in the affirmative. Representative Luxembourg. Representative O'Day.
Representative O'Day votes yes.
Could you please repeat? We're seeing Senator Lesser's face.
Representative O'Day votes yes.
Representative O'Day has voted yes. Representative Palm.
Representative Palm votes yes.
Representative Palm has voted yes. Representative Pavlak D'Amato.
Havelock D'Amato votes no.
Representative Pavlak D'Amato votes no. Representative Porter. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rabimbis. Representative Riley.
Representative Riley votes yes.
Representative Riley has voted yes. Senator Sampson. Representative Sims.
Representative Sims votes in the affirmative.
Representative Sims has voted in the affirmative. Representative Veach.
Representative Veach votes no.
Could you please repeat?
Representative Veach votes no.
Representative Veach has voted no. Representative Walker. Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Hey, Deb, Senator Sampson is a no. And I was here. You just went too fast.
I'm sorry. Thank you, Senator Sampson.
All right. Moving on. Next on our agenda will be item number 5, House Bill number 6491, an act concerning non-lethal electronic defense weapons. The members should be in possession of LCO number 6454. I'll ask for a motion for JFS.
So moved.
And a second?
Second.
I have a motion from Senator Winfield, a second from Representative Fishbein. This bill before us attempts to deal with the issue of electronic defense weapons or tasers and eligibility to possess those types of instruments, particularly in response to certain court precedents. What this bill essentially would do is allow someone to possess and own a taser if they are over the age of 21 and have one of the recognized permits to hold either firearm or ammunition under Connecticut law, thus requiring them to complete a background check and the other requirements encompassed in Connecticut law. Questions or comments on this bill? Questions or comments? If not, Representative Fishbein, do you have a motion?
Yes, Mr. Chairman. Mr. Chairman, I make a motion that we create a consent calendar and that we move item 5, which is HB 6491, with the JFS language to that consent calendar.
Is there objection to placing this item on consent? Is there objection to placing this item on consent? If not, that is so ordered. Next, we will turn our attention to House Bill number 6548, which is item number 8 on our agenda, an act concerning the recommendations of the Jury Selection Task Force. The members should be in possession of JFS language. It's LCO 6173. Can I have a motion for JFS?
So moved.
Second. And a second. Okay. I got a motion from Senator Lesser, a second from Representative Sims. Representative Blumenthal, would you like to explain the bill?
Thank you, Mr. Chair. This bill is the result of a year-long task force chaired by the Chief Justice of the Connecticut Supreme Court, and incorporated attorneys and practitioners from all areas of civil and criminal and family practice in the state of Connecticut. And the goal of this task force was to modernize our jury selection system to increase the diversity of the jury panels that we select, to ensure that the jury panels come from a fair cross-section of the community, and ultimately to better guarantee the enforcement and effectuation of every individual's right and responsibility to serve on a jury, and also to ensure that every person who has a case before our courts gets a jury of their peers. In service of that goal, the task force made a number of recommendations, some of which we have before us today. A short summary of them is the following. The bill increases the number of people and the kinds of people eligible to serve on a jury in the state of Connecticut by eliminating certain categorical restrictions. It increases the data collection by the jury administrator of a number of demographic and other categories that make up our jury panels and our veneers persons. It recalibrates the jury selection system and jury summoning system so that more equitably distributes jury summonses throughout our different communities in the state of Connecticut. And it increases the pay and provides for childcare resources for jurors who serve on panels so that neither financial hardship nor childcare needs nor transportation needs will be an obstacle to people of more limited means serving on our juries. It is a really groundbreaking piece of work to move our jury selection system forward, and had the widespread support of the task force. So I move passage.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I do recognize a lot of good work has gone into the document that's before us. And I want to commend the various members of the committee. I know that Representative Blumenthal, I think he was the only elected official that was on the committee. And Mr. Chairman, as you're aware, my objection that's shared by members of my caucus is particular with regard to lines 12 through 15, which presently one has been convicted of a felony within the last 7 years, or is the defendant in a pending felony case, is precluded from serving on a jury. And the effect of this language, lines 12 through 15, would be to remove that impediment to serving on a jury. I find it a lot of the bills that we deal with this session have to do with erasing the past, erasing the fallout from one choosing to break the law. And it's interesting, I guess it's a comment upon policy and society of this legislature, that one who has just been let out of prison yesterday can serve on a jury. Within months, the notice would have to come after they've been let out of incarceration. But that's a troubling aspect of this. Ironically, one would say, well, the legislature did something similar with regard to the right to vote in 2012, I believe it was. Of course, that right for felons is contingent upon restitution being paid to the victims if that was ordered by the court. There's no such requirement in this legislation. Ironically, one who had been convicted of violating our voting rules and statutes, convicted of a felony, would then be able to serve on a jury and to vote. So, I had hoped that we'd be able to work out this language and to leave that bar in there my understanding has been recently corroborated is that lifting this bar only affects 0.27% of the people that get a jury service notice, and that equates to 1,558 people on average. It's a very small percentage of individuals, and it's a shame that we can't come to an accord on this particular portion of this legislation, because there are some good things in here, but I have a lot of trouble with that particular portion of this proposed legislation. So thank you, Mr. Chair.
Thank you. Representative, let me just say, you and I have had quite a bit of conversations about this particular section, and with the vice chairman as well. I understand where you're coming from. Although, I think I come to it from a different perspective. I think someone who has served their time and is out post-sentence should be eligible for jury service. Doesn't mean they're going to be selected to serve on that jury. As you know, we have individual voir dire in this state. Lawyers have an opportunity to inquire. Judges can decide if someone is right. There are preemptory challenges, et cetera, et cetera. Perhaps somebody just coming out on a sale of drugs charge may not be the best candidate to sit on that exact type of case, but maybe on a breach of contract claim or a auto accident case in a civil context, they may be a perfectly suitable juror. So, I'm sure this conversation will continue as this bill moves forward, but I do think it's important that this bill move out kind of as presented to us by the task force, as they have done, as it was impaneled by a separate and co-equal branch of government. They've presented certain recommendations to us to move those forward and allow the legislature as a whole to consider this as it moves along. But certainly I'm sure this is not the end of the conversation on this particular provision, as you alluded to.
Thank you, sir.
Representative Palm, I had next.
Thank you, Mr. Chair. You actually answered my question, which was to ensure that allowing those who serve their sentence to be considered for jury duty in no way obviates the process. That was what I wanted to explain, and I agree.
Representative, you broke up on us a little bit, but certainly, if I understand your question, no, it's not an automatic jury service. It's that someone could be summoned for jury duty, as I understand it, and then what ends up happening with that, whether they actually serve on a jury is up to the lawyers and the judge of the particular case.
Right. Thank you. Well, for that reason, I will be voting in favor of this because I do believe it's important for folks who've served their time to have purchased back in society. And this is a right that I believe they deserve. So thank you for your hard work, and Representative Blumenthal as well.
Thank you. Representative O'Day.
Thank you, Mr. Chair. Look, I come at this, and my good friend who was on the committee, I'm sure, did a great job. I was not present for any of those meetings, obviously, but this is frankly one-sided for, as someone who is coming at this from the civil defense aspect. I know there was a one other defense lawyer in a civil sense on the committee. There were at least two from the plaintiff side on the committee. But when I reached out to the person, they didn't have any input on this aspect, the allowing felons to sit on a jury within 7 years of their release. And so I don't think there was a perspective from the civil defense side on this committee. And so a number of questions I have about this have not been answered. One, there are more white convicted felons in Connecticut who have been excluded based on this prohibition that we've been had for many, many years than minority convicted felons. And so when I'm picking a jury, convicted felons, whether you're white, black, whatever your nationality, race, is irrelevant to that jury selection process, in my opinion. And when I'm picking a jury, a convicted felon, I have yet to meet a convicted felon who doesn't have some reservations about the system, good, bad, or indifferent. They have a prejudice. When you go through, I've tried over 40 cases to verdict in my 30 some odd years. I've picked hundreds of in juries in hundreds of cases. All of us have a certain amount of pre-existing opinions and beliefs going into a case. And as a juror, as a lawyer representing the defendants in a civil case, you have to pick jurors who aren't going to have a pre-existing leaning towards the other side. And so just as, a person in a car accident who had a car accident within a few years of, if I'm representing a defendant in a car accident, we generally get excused for cause anybody that's had a car accident within the last few years. Plaintiffs' counsel have generally agreed to that. If we now say felons are able to sit as jurors, for example, in a police defense case where a policeman is charged with excessive force, most reasonable plaintiffs' lawyers would agree a felon should not sit on that type of a case, particularly if there was an arrest that got physical. The public policy that we had in place for many, many years for excluding convicted felons for 7 years or less made sense for many, many years. And now it doesn't. And I have not been given a reason why. If anyone here, if any of the proponents of this bill can tell me what public policy changed from a couple years ago to now to say that convicted felons within the last 7 years should be jurors, I'm all ears. Mr. Chair, if you have an opinion on that, I'm happy to listen.
Representative O'Day, obviously this is a recommendation that came to us from the Judicial Branch's task force. As mentioned, Representative Blumenthal sat on that task force, so I'll let him summarize the deliberations.
Thank you, Mr. Chair, and through you, in answer to Representative O'Day's question. I'll start out just by addressing several of the concerns he's voiced. First of all, based on my experience on the task force, my perspective, I'm not disputing yours necessarily, was that the civil defense bar was represented and agreed, frankly, with this position or agreed with the position ultimately taken by the task force on this issue, as far as I could tell. And I would just point out that, as you noted in your discussion, convicted felons can already serve on juries. It's just that they have to wait 7 years after their conviction. This categorical bar results in inequitable results because there's a wide variety of felonies and acts constituting felonies for which someone can be convicted. You could have someone who got convicted of a felony that is relatively minor. They went to prison for less than a year, and then they're out and they've paid their debts to society and they've been living a otherwise blameless life for another 5 years, but that person could still not sit on a jury, and it's a categorical bar. Whereas someone who's convicted of a much more serious felony and is imprisoned for 7 years or a number of years that's just under that could be able to serve under current law immediately after being released. I would make a few additional points. In Connecticut, we have a state constitutional right to individual voir dire. And for the non-lawyers among us, what that means is that every juror in a case that's going to go to trial is questioned by lawyers for all sides in the case so that they can ferret out any issues that may make the potential juror unsuitable for that particular case. And in that process, in that questioning process, if information is revealed that may create a concern, like Representative O'Day mentioned, that they may have had a negative experience with the criminal justice system, or that their experience with the legal system more generally has in some way colored their ability to be fair in any particular case, that prospective juror who is a convicted felon can still be excused for cause. Even if they don't reveal some sort of bias that's more clear and concrete, if an attorney has a feeling through the information they ferreted out that that person may not be fair to their client, they can still excuse that juror so that they will not sit on the jury through what's called a peremptory challenge, which is one for which you don't have to list a reason. So there are a number of protections still in place to prevent jurors who are convicted felons who are unsuitable for any particular case from reaching the jury box. And I would then I'll transition to answering the substantive policy question for why the jury selection task force felt that this measure was important. First of all, the jury selection task force felt that being a juror, being eligible for jury service is an essential part of your rights and your duties as a citizen. And the feeling was on the task force that people who have paid their debt to society, regardless of how long in imprisonment that debt is or how long it's been since they were convicted, should be eligible potentially for jury service. They shouldn't be categorically barred because it is such an essential part of being a citizen. The jury selection task force also felt that it was really important from the perspective of any particular litigant, because litigants have a right to jury of their peers. And it turns out that a number of our peers include convicted felons. And so the jury selection task force felt that it was important that that category of our community, that category of our peers, is not categorically barred for 7 years from jury service. They may be still ineligible or not well advised for any particular trial, and they may be excluded on that basis. But the feeling was that barring them categorically and absolutely for 7 years was not fair to the individual, but it's also potentially not fair to the litigant or to the justice system. Thank you, Mr. Chair.
But my understanding.
Thank you, Representative O'Day.
Thank you, Mr. Chair. So my understanding is there's only one other state that agrees with that position. Is that correct? Maine? Through you, Mr. Chair.
Representative Blumenthal.
Through you, Mr. Chair, I'm not aware of the other states that may or may not have this exact provision. My understanding from our work in the task force was that 7 years was on the upper limit of that. But I'm not sure of how many other states have no categorical prohibition on felon serving.
So I asked that exact same question, and I was told it was one other state, Maine, has that. So my question still stands. Why was this good public policy for 49 other states and Connecticut 2, 3, 4, 10 years ago, but it's not good policy now?
Representative Blumenthal.
Through me, Mr. Chair, I think the jury selection task force, and again, the task force drew from all areas of practice, was that it was really not ever good policy for any state. And to just in response to the question of Representative O'Day, there's no indication in Maine that their lack of a categorical provision on felon serving for any period of time has had a deleterious effect on their justice system. So I think the jury selection task force came to the conclusion that the previous policy was an error and that it should be changed. Thank you, Mr. Chair.
Further questions, Representative O'Day?
Yes, please. So I understand it. So 49 other states and Connecticut, as of, up until now, had it wrong. And now we're going to change our public policy based on, now, I just respectfully disagree. But let me put it this way. Let me ask this. In task force, who was the commercial defense attorney or any defense attorney in a civil context who spoke or had any input on this particular part of the legislation?
All of the task force members had input on this part of the legislation. We all voted on it. I could call up the list of the members of the task force, and I'd be glad to talk to you online. I'm not sure if we want to individually call them out right now, but they all had an opportunity to partake and vote on the ultimate measure, even if they weren't on the subcommittee that considered it.
Yeah, I don't need to do that, call them out all individually. I went through the list. There was only one civil defense attorney, and I contacted him, and he did vote on it, but he didn't have any input. So, look, to be clear, as attorneys, we know jury selection is trying to get a balanced jury. You generally, the prohibition of having convicted felons on a jury within 7 years is because they were in jail, so they don't have a work history. There are many reasons why public policy was that they have an animus or a negative feeling towards the system. I mean, it's just for the same reasons that you wouldn't pick a person who was in a car accident to be a juror in another car accident within a certain period of time. 20 years after the accident, it's fine, but immediately a year or two after the accident, you don't want that person on the jury. And normally they're excused for cause and you don't have to use a preemptory. Here we're now making it a blanket statement saying felons could be on a jury and that, you have to question them individually. And if they, what's going to ultimately happen in this scenario is defense lawyers are going to have to use more of the preemptories to get rid of convicted felons. And I'm not saying, remember, to preface this, there are more white people, white convicted felons in Connecticut as a pure number than there are minority. So I don't see this as the goal from the task force was a jury of your peers. Well, parties, their felony convictions generally are inadmissible unless they're recent. And then the specifics are not allowed. So I don't see this as solving the issue that wants to be solved, that is trying to attempt to be solved with this legislation. But look, why we're going from 7 to 0 when no other state besides Maine does that, I think speaks volumes. At the very least, I mean, the fact that you could have a bipartisan bill if we went from 7 to 5, and the fact that the committee is choosing to not engage us in any type of negotiation on that is disappointing. And I would urge my colleagues to vote against this. It's not fair to civil defense lawyers, in my humble opinion. Thank you very much, Mr. Chairman.
Thank you, Representative O'Day. Senator Sampson.
Thank you, Mr. Chairman. I just had a simple question, and forgive me, it might be included in the bill, but there was some conversation early on about whether or not this provision that allows felons within 7 years to begin serving on a jury, does that apply to folks who are on parole or who may still owe fines or some sort of restitution to the state or victims? Through you, Mr. Chairman.
Representative Blumenthal.
Through you, Mr. Chair, it would apply to all people who have been released from physical custody of the Department of Corrections.
So I'm gathering based on that, that would mean that someone who has been released but is still on parole, they would be an eligible juror at that point. Through you, Mr. Chairman.
Representative Blumenthal.
Thank you. Through you, Mr. Chair. Yes, they would be a potentially eligible juror, again, subject to all the questioning and other potential challenges that every other potential juror is on any particular case.
All right, thank you very much for those answers through you, Mr. Chairman. Yeah, you know, the thing about this bill is that I'm very sympathetic to the argument that once you've paid your debt to society, at least as far as any state sanctioned activity goes, you should be the same as any other citizen. But you lose me when you start to include people who have not yet paid their debt to society. You know, we have similar bills in the GAE committee about restoring voting privileges. And I certainly believe if you are convicted of a crime, you serve your time, you should have your voting rights restored. There's an effort to try and restore voting rights to people who still owe fines and are on parole. And I just think that there should be a bright line when you're done paying your debt to society. This bill is something that I had intended on supporting because I do believe very much that once you've served your time, you should be back to eligibility as a juror. But I can't support something that that allows someone still on parole because they're not done. They're still in the custody of the Department of Corrections, whether or not they are actually incarcerated or not. And I believe we need a bright line there. And I'll just put that on the record. The fiscal note is obviously a grave concern as well. So I'll be voting no today, Mr. Chairman, but I want to tell you that I'm sympathetic to the desire to restore people's ability to participate as jurors. And if you want to get my vote, I think you know what you need to do. Thank you, Mr. Chairman.
Senator Lesser. Senator Lesser, did you have a question? No. Okay. Representative Palm for the second time? Or is your hand still up? No. Okay. Then Senator Winfield.
Thank you, Mr. Chair. I want to first thank Representative Blumenthal and the members who worked on this of the actual task force for their work. I am supportive of this. It doesn't matter to me whether the people who have been in our prison system are white, black, or anything else. And absolute numbers aren't what we're talking about. We're talking about percentages as it relates to the population. But I just want to say that the notion that someone has a reservation about the system should not exclude them from participating in a jury. I wouldn't be doing a lot of the work that I do if I didn't have reservations about the way that our system works. I'm working to do what I think improves our system on many levels, but I can be fair. The fact that someone went to a prison and spent time there does not mean that there's inherently a point of view. There have been studies done on people who've been in prisons, and what they discovered and their view of the system was that they were all over the place, just like the rest of society. And we know that we allow for people who protect us, our police officers, to serve on juries. And when they study them, they have a tendency to side with the prosecution, and yet we don't bar them. There's nothing inherently true about the perspective that someone has because they've been in the system. As a matter of fact, I've met people who are harder on people who've been in the system than people who are outside of, who've always been outside of this system. We are talking about, if we're talking about the language that currently exists and we want to do something about those who are currently going through the system, I'm actually open to having that conversation. But if we're talking about people who are post-sentence, who are out, who experience all of the things that through policy we have put in place to make their lives more difficult to reintegrate into society, I think we have to think again about what it is we are doing. the society says to these people, you've been to prison, you've done what many of our mothers and fathers told us you have to do if you commit a crime, which is serve the time. And yet, again, in this way, we keep you from participating. I don't think that's good public policy. I don't think it ever was. And to answer that question, not all of us have been asked what we think about the public policy that exists. Because I think if we did ask people who don't always get asked the question, the answer we would get would be that that public policy should not exist. And so that's the question before us. Do we think it is or isn't good public policy? Do we think this is or isn't good public policy? And on that question, I come down on this is good public policy. Thank you, Mr. Chair.
Thank you, sir. Further questions or comments? If not, Madam Administrator, please call the roll.
And that was HB 6548, JFS, proposed substitute LCO number 6173. Senator Winfield.
Senator Winfield in the affirmative.
Senator Winfield has voted in the affirmative. Representative Staffstrom.
Representative Staffstrom in the affirmative.
Senator Staffstrom has voted in the affirmative. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel. Representative Fishbein.
Representative Fishbein regretfully votes no.
Representative Fishbein regretfully votes no. Senator Anwar. Senator Bradley. Representative Callahan.
Representative Callahan votes no.
Representative Callahan has voted no. Senator Champagne.
Senator Champagne votes no.
Senator Champagne votes no. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry.
Representative Curry votes yes.
Could you please repeat?
Representative Curry votes yes.
Thank you, Representative Curry. Representative Dillon.
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative DeMassa.
Representative DeMassa votes yes.
Representative DeMassa has voted yes. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes no.
Representative Dubitsky is voting no. Representative Fiorello.
Representative Fiorello votes no.
Representative Fiorello votes no. Senator Flexer.
Senator Flexer votes yes.
Senator Flexer votes yes. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Could you please repeat?
Representative Gilchrist votes yes.
Thank you, Representative Gilchrist. Representative Godfrey.
Yes, Representative Godfrey votes yes.
Could you please repeat?
Representative Godfrey votes yes.
Perfect. Thank you, Representative Godfrey. Representative Harding.
Representative Harding votes yes, or excuse me, no. Representative Harding votes no.
Representative Harding has voted no. Senator Haskell. Representative Howard.
Representative Howard votes no.
Representative Howard has voted no. Representative Labriola.
Representative Labriola votes no.
Representative Labriola has voted no. Senator Lesser.
Senator Lesser votes in the affirmative.
Senator Lesser has voted in the affirmative. Representative Luxembourg. Representative O'Day.
O'Day votes no.
Representative O'Day has voted no. Representative Palm.
Representative Palm votes yes.
Representative Palm has voted yes. Representative Pavlak D'Amato.
Pavlak D'Amato votes no.
Representative Pavlak D'Amato has voted no. Representative Porter. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Sorry, Representative Quinn. Representative Rabimbus. Representative Riley.
Representative Riley votes yes.
Representative Riley has voted yes. Senator Sampson.
Senator Sampson votes no.
Senator Sampson is voting no. Representative Sims.
Representative Sims votes in the affirmative.
Senator Sims votes in the affirmative. Representative Beach.
Representative Ve-
Representative Veach votes no. Representative Walker, Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Thank you, Madam Administrator. We will move on. Next up will be item number 9 on our agenda, House Bill number 6665, an act concerning the removal of restrictive covenants based on race and elimination of the race designation on marriage licenses. The members should be in possession of LCO number 6369. I'll entertain a motion for JFS.
So moved.
And a second.
Second.
I got a motion from Senator Winfield, a second from Representative Sims. The bill before us codifies Supreme Court precedents, which voids race-based restrictive covenants on land and allows a process for removal of those offensive designations. It also removes the requirement that somebody swear to their race on an affidavit of a marriage license. I'd like to thank Representative Doucette in particular for his work on, and as well as Representative Fishbein for their work on the JFS language before us, which hopefully addresses the concerns we heard, not on the substance or content of this bill, but on the technical mechanism of the bill. Representative Fishbein.
Thank you, Mr. Chairman. Discrimination comes in various different ways. Some is implied. I know on my first day of Catholic school, because of my last name being Fishbein, one of the nuns took me aside and said, "Are you sure you're Catholic?" She had felt that because of my last name that Catholics don't have the last name Fishbein. Well, that's what I was born in. But that was her employing her stereotypes to my last name. That's an implied discrimination. What this bill does here today is it deals with overt. It says that there's certain things in our land records that are discriminatory. They are racist. And we address those things, those overt examples. And that's a good thing that we're addressing that. Quite frankly, I was shocked that they existed in our state. And that was my naivety and ignorance. So I'm glad that we're addressing that in Section 1. And Section 3 is actually a bill that Senator Winfield and I think we're the only co-sponsors of the bill last session, which, once again, I was appalled that in order to get a marriage license in the state of Connecticut, you have to declare your race. That, is a discriminatory practice. That's not something that should be a requirement to enter into marriage, in my opinion. And I hope that others join my support for this. And I have to share my respect for Representative Doucette working over the Easter weekend on getting this language together so that we could have this bill here today. So thank you, Mr. Chairman, for the opportunity.
Thank you. Representative Trubisky.
Thank you, Mr. Chairman. We have in this committee and in a number of other committees, there are a number of bills that seek essentially to have the state take over a significant portion of zoning authority from towns under the auspices of reducing racism in zoning. Zoning certainly has vestiges in Connecticut of being used for racist purposes. Land records in Connecticut are still there are still places where these vestiges exist in the titles of land records and in restrictive covenants that restrict the alienations, the sale and the sale of property to people of certain races. And those vestiges should be removed and gutted from the land records because they are a horrible reminder of the past racist policies that existed in this state. I support removing those, but I do think it's important to recognize that this removal and this the policies involved in removing these vestiges is a very different thing than zoning. And zoning today is used for purposes that are entirely separate from the racist past. So I do support removing these vestiges, even though they are no longer clearly no longer enforceable. They should not remain on land records as excuse me, as restrictive covenants. But you know, as bills come up that address zoning, let's remember that there's a big difference between this bill and the bills that address zoning, and these are the vestiges of racism, and zoning is not. So I do support this bill, and I encourage everybody to do so. Thank you.
Senator Lesser.
Thank you. I do feel I wasn't planning to speak, but I will speak brief support of the legislation. I think it is long overdue, but I would make just a quick point that the Supreme Court of the U.S. Struck down restrictive covenants as unenforceable way back in 1948. But I would submit to the committee, I don't think there's a single member of this committee that believes that segregation disappeared in the U.S. in 1948. Clearly, we have more work to do. If only the legacy of segregation were limited to restrictive covenants, we would be in a much better place as a country and as a state. While this bill is a good gesture, it doesn't ignore the substantive work that I think still lies ahead of us. Thank you, Mr. Chairman.
Thank you, Senator. Senator further questions or comments? Senator Winfield.
Yes, briefly, Mr. Chair. I want to thank representatives who used their Easter weekend to work on this. And I want to thank Representative Fishbein for making sure that we get here with this bill and connect this bill to the bill that he and I both supported, and not forgetting about that. I think that both things are important. And I appreciate the fact that where I forgot, he remembered and made sure that we find ourselves at this moment dealing with both issues. Thank you, Mr. Chair.
Thank you, Senator. Further questions or comments on this legislation? Further questions or comments? If not, Representative Fishbein, do you have a motion you could make?
Yes, Mr. Chairman, I move that we move this item to the consent calendar.
Is there objection to placing this item on consent? Is there objection to placing this item on consent? Hearing none, so ordered. Next up, we'll be turning back to item number 3 on our agenda, Senate Bill number 1093, an act concerning civilian police review boards, security cameras, body-worn recording equipment, and searches by police. Do I have a motion for a JF?
So moved.
And a second.
I'll second.
A motion from Representative Fishbein and a second from Representative Howard. This bill before us does several things. The first of which is to deal with the issue of a subpoena by a civilian review board and what are the mechanisms for enforcement of that subpoena, as well as an objection to that subpoena. And actually, before we move on, I believe Representative Fishbein, on the first section of this bill, you'd like to move an amendment?
Yes, sir. I believe that the administrator is in possession of an amendment which strikes lines 17 through 28 and replaces that. I'm going to move the amendment.
And I will second the amendment. Representative Fishbein, do you want to explain what the amendment does?
Yes, sir. It merely adds to the end of the clause, which shall adjudicate such objection in accordance with the rules of the court, to make it clear that the rules of the Superior Court are to be followed with regard to adjudication of any such objection to a subpoena.
Discussion on the amendment. Discussion on the amendment. I would just briefly ask members to support the amendment, as I believe it makes clear that the provisions with respect to subpoenas are governed by our existing court procedure and practice book. If there's no further discussion, let me try your minds. All in favor of the amendment, please signify by saying aye.
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 Is any opposed to the amendment? Hearing none, the amendment is adopted. Madam Administrator, if you could take that down, I'll explain the remainder of the bill. The other provisions of the bill modify provisions concerning viewing by a police officer of body-worn recording equipment and dash camera footage, and importantly, allow a court to draw an adverse inference against a police officer who turns off their body camera. That adverse inference would be drawn both in a criminal matter where the police officer turned off their body camera and are being prosecuted for excessive or illegal use of force. That adverse inference could also be drawn in a civil action, such as a civil rights type suit against the police officer or the department. This bill also, as folks know, last summer, we passed a law that banned police officers who were decertified in Connecticut from serving as security guards. This bill would ban those police officers who are decertified in another state from serving as security guards here in the state of Connecticut. This bill also bans so-called no-knock warrants and makes the use of no-knock warrants illegal in Connecticut. And finally, the bill modifies the ban on consent searches and says a police officer can only engage in a consent search, can only ask for consent to conduct a search where they have reasonable articulable suspicion that either the person or the car contains drugs, contraband, or other illegal material, and that they must, whether the officer receives consent or not, once they ask, they must provide a report of what their reasonable articulable suspicion was, why they asked for consent. Question or comments on the bill? Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I remember over the last year or so hearing about an incident in a different state where a no-knock warrant was effectuated, and an individual inside of the home didn't know that the police are going to come to the home, thought it was an intruder, and sought to defend themselves, and the officers opened up fire and ended up killing the girlfriend of the individual. This bill would help to make sure that something like that doesn't happen in Connecticut. But there was a tragic incident, and I understand, you know, going back and forth about this. It's not the perfect bill, and certainly there's a lot of protections in here, especially the consent search aspect where, you know, an officer, they have to document why they did it. And with the advent of body cams and dash cams and all of that stuff, if one goes and complains, you know, I was asked to be searched, there's going to be that documentary proof that that happened. And then there's going to be the follow-up. Well, officer, where's your report? And, you know, they're going to have to state why they engaged in that activity. Those are protections, not just for the police, but for the public at large, so that the power of the badge is not overused in an improper fashion. So I thank you for working together on this bill. As I said, you know, not perfect, but there's some things that I think help both sides as we go forward. So thank you, Mr. Chairman.
Thank you, Representative. Further questions or comments on this? Senator Winfield.
Thank you, Mr. Chair. So I am going to be a no, and I'm not asking people to follow me or not follow me in that no. I have a little bit of frustration here. And, you know, I've listened to people for years talk about they're voting no to flag a bill, and I never really understand what that means, to be honest with you. Because oftentimes there are people who are no longer in the conversation until a bill shows up again. But certainly I will be in this conversation, as I suspect this bill will get out of the committee. So I guess I'm voting no to flag this bill. And I mean that really. It's interesting to me that I've been in this legislature since 2009. And over and over and over again, I have been told on some very heavy issues, we did that last year. We can't do that this year. And yet on the issue that pertains to the police accountability bill that we did just a few short months ago, not only could we bring the subject back up in this session, but we could bring it up multiple times in this session. And it just makes me wonder how that's possible. How it's possible that when I'm talking about people who've been sexually assaulted, because a couple of years ago, we couldn't bring that issue up because we've just done it. How, when I'm talking about people who've lost their rights in one way or another, we couldn't do it. And a panoply of things, we cannot do it. But on this, we can do it as many times as we feel like doing it. It gives me pause. And sure, there are things in this that are, I think, perfectly fine, and things I don't agree with, which is why I'm not asking people to necessarily follow my lead. But it gives me pause that we can't do all of that other stuff simply because it was done the year before. And not even that it got passed, that we attempted to do it the year before. And so I'm frustrated. And I want to think about that as this moves forward and we have further conversation about it. And maybe at the end of the session, this bill is passed into law and everybody can go forward. But at this moment, I don't get it. And I need time to figure that out. Thank you, Mr. Chair.
Thank you. Further questions or comments? Representative Fishbein?
Thank you, Mr. Chairman. I think the senator knows that I want him at the table, and I think I've included, and we've all talked about this this bill as we've gone forward. And I just want to, address the use of force bill that we dealt with previously was because of the date that it went into place. And I think we negotiated in good faith on that. And I think everybody walked away with a good bill, not only to do some things to change the portions of the police bill, but to protect the public at large, quite frankly. So I just, I think the senator knows that I, for one, certainly want him to be part of any discussions. So, thank you. Thank you, Mr. Chairman.
Thank you. Representative Palm.
Thank you, Mr. Chair. I want to honor what Senator Winfield just said, and I deeply respect his expertise, his experience, and his words. I am going to vote reluctantly to advance this bill because I have frequently been critical, at least inwardly, of folks who aren't willing to further conversations by voting the bill to refine it and to keep the conversation going. So in the spirit of doing that, I'm going to vote yes today so that I can listen and learn and continue the process of deepening my understanding of what we're trying to accomplish. That said, I have grave concerns about that, and I'm going to be listening very carefully, and I thank everybody who has worked hard to continue to move this very well-intentioned original bill forward.
Thank you, Representative. Representative Rabimbus.
Thank you, Mr. Chairman. Thank you for the opportunity to speak. I did want to certainly acknowledge and recognize Senator Winfield's frustration, especially in light of the fact that I have for many years enjoyed working with him in a bipartisan manner on many different pieces of legislation that's come before this committee. I share the good senator's frustration. I will at any time sign off, co-sponsor, push, support a proposal that would say that anything that gets passed, that we would give it a certain period of time. But I think the reality, especially as the minority party, we don't really get to choose many times the topics that get raised. Actually, hardly ever we do have an input, and I think the respectful professional relationships we've enjoyed on the Judiciary Committee in that regard. But proposals do come before us on multiple occasions for a variety of different reasons. One of which is simply not getting the results that the person seeks. And we've seen that with the proposals for legalization of marijuana. We've also seen that for proposals regarding the death penalty and a variety of other issues. So that is one of the reasons. One of the other reasons certainly is after passing legislation, and sometimes even during the debate, issues are raised of concerns that may occur as a result of unintended consequences or consequences that were known at the time of the proposal. I think, in my humble opinion, this was one of them. I think that people did, rightfully so, raise some concerns regarding some potential unintended consequences, as well as some serious consequences, some of which we've seen already manifest and others we may not have yet and may never see. I think, having enjoyed a professional relationship with the good senator, I couldn't imagine this topic, or really any topic of importance, continuing without his input and his involvement. I'm a true believer, no matter how the outcome is, that anytime that there's input from both sides, that it's could only lead to better legislation, period. I don't care what the topic is. So with that, I just thank the chairmans, the ranking members, and the members of this committee, really, to allow this discussion and public hearing, and now certainly a further discussion and or debate on the issue of trying to address and making something that passed even better. And then again, I certainly do share the frustration of repeat bills, especially in today's climate, especially when it comes to the business community, having to look over their shoulders constantly for same proposals being, I guess some people would say good proposals, other people would categorize it as bad proposals being proposed after and after and after, even after hundreds of people testify one way or the other on something. It's frustrating, no question about it. It's frustrating to the public. It's frustrating for us as lawmakers. But certainly it's what we signed up for. And I truly appreciate the ability to do it on this proposal specifically, because I do believe that the changes are being made is certainly addressing the issues that were raised during special session and certainly addressing them in a better manner. So thank you, Mr. Chairman, for allowing me to speak. And thank you again to the leadership of this committee and all of the members of this committee for allowing this topic to move forward.
Thank you, Representative. Further questions or comments from the committee? Further questions or comments from the committee? If not, Madam Administrator, Senator Winfield? Good.
No, I was turning my camera on.
All right. Madam Administrator, please call the roll.
That was Senate Bill 1093, which is a CFS with the addition of Amendment A offered by Representative Fishbein and seconded by Representative Snapstrom. Senator Winfield.
Senator Winfield in the negative.
Senator Winfield has voted in the negative. Representative Snapstrom.
Representative Snapstrom votes yes.
Senator Snapstrom has voted yes. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel. Representative Fishbein.
Sorry. Representative Fishbein votes yes.
Senator Fishbein has voted yes. Senator Anwar. Senator Bradley. Representative Callahan.
Representative Callahan votes. I'm sorry, I'm losing my connection. Representative Callahan votes yes.
Okay. Yeah. Could you just repeat?
Did you get me, Madam Administrator?
I didn't.
Representative Callahan votes yes.
Perfect. Thank you so much. Senator Champagne.
Senator Champagne votes yes.
You please repeat.
Senator Champagne votes yes.
Senator Champagne has voted yes. Thank you. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry.
Representative Curry votes yes.
Representative Curry has voted yes. Representative Dillon.
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative Damassa.
Representative Damassa votes yes.
Representative Damassa has voted yes. Representative Doucette.
Representative Doucette votes no.
Representative Doucette has voted no. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky has voted yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello has voted yes. Senator Flexer.
Senator Flexer votes no.
Could you please repeat?
Senator Flexer votes no.
Senator Flexer has voted no. Thank you. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Could you please repeat?
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
And Representative Godfrey votes yes.
Representative Godfrey has voted yes. Thank you. Representative Harding.
Representative Harding votes yes.
Representative Harding has voted yes. Senator Haskell. Representative Howard.
Representative Howard votes yes.
Representative Howard has voted yes. Representative Labriola.
Representative Labriola votes yes.
Representative Labriola has voted yes. Senator Lesser.
Senator Lesser pass.
Senator Lesser, did you say pass?
I did.
Okay, thank you. Representative Luxembourg. Representative O'Day.
Representative O'Day votes yes.
Representative O'Day has voted yes. Representative Palm.
Representative Palm votes yes.
Representative Palm has voted yes. Representative Pavlak D'Amato.
Pavlak D'Amato votes yes.
Representative Pavlak D'Amato has voted yes. Representative Porter. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rabimbis.
Representative Rabimbis votes yes.
Representative Rabimbis has voted yes. Representative Riley.
Representative Riley votes yes.
Representative Riley has voted yes. Senator Sampson.
Senator Sampson votes yes.
Senator Sampson has voted yes. Representative Sims.
Representative Sims votes in the negative.
Representative Sims votes in the negative. Representative Beach. Representative Walker and Representative Young.
Representative
Did you
Young
hear
votes
me?
yes.
I'm sorry, Madam Chair. Did you hear me?
I did not hear you.
Okay, I'm sorry. Representative Beach votes yes.
Representative Beach has voted yes. And Representative Young, I did catch you saying that you had voted yes as well.
Yes, thank you.
Thank you.
Madam Administrator,
Yes, Senator Lesser.
Senator Lesser in the affirmative.
Senator Lesser has voted in the affirmative. Thank you.
All right, moving on to the last item we will take up today, which is item number 7 on our agenda, House Bill number 6539. The member should be in possession of JFS language, JFS LCO number 6389. I'll entertain a motion for a JFS.
So moved.
Second.
All right, I got a motion from Representative Fishbein, a second from Representative Howard. The original title of this bill was an act concerning commercial driver's license holders and pretrial education programs. The new language, the substitute, is titled an act concerning a study of the use of kratom in Connecticut. I want to thank Representative Fishbein for his work and bringing this strike all amendment to this bill before us. The new bill actually deals instead of with commercial driver's licenses, because I know there was quite a bit of opposition to the underlying bill. That has all been removed, and the new substitute language instructs the Department of Public Health to study kratom, which I guess is some sort of leaves of a tree species that has some hallucinogenic or other negative effects. And I am probably butchering this badly, so I am going to actually turn it over to Representative Fishbein, who I think could probably do a much better job of explaining than I can.
Well, thank you, Mr. Chairman. I don't think you butchered it that badly. If your intent was to butcher, anyway.
It wasn't my intent, Representative. I just caught the side eye and figured I was going astray.
No problem. Evidently, this product does come from a leaf. There have been, complaints about the fact that this product is being sold to children, particularly at gas stations, things like that. And this bill asks for a study of, do we do something about this? My understanding also is that this product is also prescribed because there are supposedly some benefits. So that's the intent of this bill. And I do thank the chairs for permitting the submission of this replacement language, because this was just brought to my attention halfway through the session. So thank you, Mr. Chairman.
Thank you. Representative Fishbein, just for the record, this would be considered a strike all replacement, correct?
I did note your stressing of that in your introductory remarks. I chose to ignore that for obvious reasons, but yes, this would be a strike all. I do agree.
Thank you. Representative Dubitzky.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to support this bill out of committee, but the irony is not lost on me that at the same time we are voting to legalize marijuana, one of the most widely used hallucinogenic drugs in the state, we're authorizing a committee to go essentially search for obscure other drugs to criminalize. It is a little strange to me that that we're doing those two things in the same meeting. As a, if we're looking to end the war on drugs, well, let's give people a little freedom and not start searching for new and improved things to ban. I'm interested to see what this committee comes up with, but I mean, the commission comes up with. But I certainly couldn't guarantee that whatever they come up with, I'm going to vote to enact into law. So that's all I had to say. Thank you very much.
Thank you. Madam Administrator, I believe I fumbled the LCO number when I brought the bill out. So I just want to be clear for the record, and Representative Fishbein, if you could verify, because I think you made the motion, that the substitute language we're discussing is LCO number 6368.
I do concur.
Okay, so 6368. So just let the record reflect that the motion is for JFS of LCO number 6368. Further question or comment on this bill? Senator Winfield.
Thank you, Mr. Chair. And you probably don't hear this that often, but I pretty much agree with Representative Dubinsky. When this first came to us, after Representative Fishbein had been alerted to Kratom and its usage, the conversation was about what other states have done. And as you may know, other states have banned the use of Kratom. And I pointed out that we were looking to legalize cannabis, and we had gotten into the landscape that we are in now, given the fact that we had made a plant illegal, and we needed to be careful. And we talked about it and came up with this language, which replaces the bill that I won't focus on too much, because we wanted to study it and find out what's really going on here and what the approach should be. And I would say that I don't know ultimately what's going to come back as a recommendation, but certainly I'm not looking to replicate what we have found with the prohibition on cannabis. But I do want to thank Representative Fishbein for bringing this issue before us. It's something I hadn't heard about. I didn't know that it was being used. I didn't know that it was being prescribed. And I think this committee, through studying it, will learn the information that we need, and then we can make an informed decision. I think that's the way to go. Thank you, Mr. Chair.
Thank you, Senator. Representative O'Day.
I just wanted to know for the record the agreement between Representative Dubinsky and our good chair, and it's duly noted. And when they agree, people should listen. Thank you very much, Mr. Chair.
Bipartisanship all around today, Representative O'Day. Further questions or comments from the committee? Further questions or comments from the committee? Senator Sampson, you had your hand up, down, and now you're flagging me. You good? All right. Representative Fishbein, is there a motion on this or no?
I believe so. Mr. Chair, I make a motion that we move item number 9. No, I'm sorry. This is item number 7, HB 6539, LCO 6368 to the consent calendar.
Is there objection to placing this item on consent? Okay, Senator Sampson objects.
Chairman, object. Yes, thank you.
Okay, all right.
I wasn't sure about that. Yep.
All right, that's why we check. Madam Administrator, if you could call the roll, please.
Alrighty, so that was 6539, the strike all amendment, making it a JFS post substitute LCO number 6368 to make it a Kratom study. Righty, Senator Winfield, how do you vote?
Senator Winfield in the affirmative.
Senator Winfield is voted in the affirmative. Representative Staffstrom.
Representative Staffstrom votes in the affirmative.
Senator Staffstrom is voted in the affirmative. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel. Representative Fishbein.
Representative Fishbein votes yes.
Senator Fishbein has voted yes. Senator Anwar. Senator Bradley. Representative Callahan.
Representative Callahan votes yes.
Representative Callahan has voted yes. Senator Champagne.
Senator
Fox.
Champagne votes yes.
Senator Champagne votes yes. Thank you. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry.
Representative Curry votes yes.
Representative Curry has voted yes. Representative Dillon.
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative Damassa.
Representative Damassa votes yes.
Representative Damassa has voted yes. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky has voted yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello has voted yes. Senator Flexer.
Senator Flexer votes yes.
Could you please repeat? We're not seeing any video.
Senator Flexer votes yes.
Perfect. Senator Flexer has voted yes. Thank you. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
And Representative Godfrey votes yes.
Representative Godfrey has voted yes. Representative Harding.
Representative Harding votes yes.
Representative Harding has voted yes. Senator Haskell. Representative Howard.
Representative Howard votes yes.
Representative Howard has voted yes. Representative Labriola.
Representative Labriola votes yes.
Senator Labriola has voted yes. Senator Lesser.
Senator Lesser, yes.
Senator Lesser has voted yes. Representative Luxembourg. Representative O'Day.
Representative O'Day votes yes.
Representative O'Day has voted yes. Representative Palm.
Representative Palm votes yes.
Representative Palm has voted yes. Representative Pablo Tomato. Representative Porter. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rebimbus.
Votes yes.
Could you please repeat?
Sure. Representative Rebimbus votes yes.
Thank you. Representative Rebimbus has voted yes. Representative Riley.
Representative Riley votes yes.
Senator Riley has voted yes. Senator Sampson.
My apologies to the committee for the roll call vote on my benefit. Senator Sampson votes no. Thank you.
Thank you. Senator Sampson has voted no. Representative Sims.
Representative Sims votes in the affirmative.
Representative Sims votes in the affirmative. Representative Veach.
Representative Veach votes yes.
Representative Veach has voted yes. Thank you. Representative Walker and Representative Young.
Representative Walker votes in the affirmative.
Thank you, Representative Walker. Welcome. Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Thank you, Madam Administrator. I think that brings us to our consent calendar. So I think there's only a couple items on there, but if you could call those and we'll have the roll on the consent calendar.
Item number 5, HB 6491, an act concerning non-lethal electronic defense weapons, JFS, proposed substitute LCO number 6454. And item number 9, HB 6665, an act concerning the removal of restrictive covenants based on race and elimination of the race designation on marriage licenses, JFS, proposed substitute LCO number 6369. Senator Winfield.
Senator Winfield in the affirmative.
Senator Winfield is voting in the affirmative. Representative Staffstrom.
Representative Staffstrom votes yes.
Let me just get Senator Anwar here. Okay. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel, Representative Fishbein.
Representative Fishbein votes yes.
Representative Fishbein has voted yes. Senator Anwar.
Senator Anwar votes yes.
Could you please repeat?
Senator Anwar votes yes.
Thank you. Senator Anwar has voted yes. Senator Bradley. Representative Callahan.
Representative Callahan votes yes.
Senator Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne has voted yes. Representative Conley.
Representative Conley votes yes.
Representative Conley is voting yes. Representative Curry.
Representative Curry votes yes.
Yes. Thank you, Representative Curry. Representative Dillon.
Representative Dillon votes yes.
Representative Dillon votes yes. Representative Damassa.
Representative Massa votes yes.
Representative Damassa has voted yes. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky has voted yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello has voted yes. Senator Flexer.
Senator Flexer votes yes.
Could you please repeat your name? That's the only part we didn't catch.
Senator Flexer votes yes.
Thank you, Senator Flexer. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Gilchrist has voted yes. Representative Godfrey.
Representative Godfrey votes yes.
Just like you were here in person. That was perfect.
I know. I love technology when it works.
Representative Harding.
Representative Harding votes yes.
You weren't so lucky.
Bob is better than me in a lot of ways. That's one of them. Representative Harding votes yes.
Thank you, Representative Harding, for your patience. Senator Haskell. Representative Howard.
Representative Howard votes yes.
Representative Howard votes yes. Representative Labriola. Senator Lesser.
Senator Lesser votes yes.
Senator Lesser has voted yes. Representative Luxembourg. Representative O'Day.
Representative O'Day votes yes.
Representative O'Day has voted yes. Representative Palm.
Representative Palm votes yes.
Representative Palm has voted yes. Representative Pavlak D'Amato.
Pavlak D'Amato votes yes.
Representative Pavlak D'Amato has voted yes. Representative Porter. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Ravimbis.
Representative Ravimbis votes yes.
Could you please repeat?
Representative Ravimbis votes yes.
Thank you so much. Representative Riley. Senator Sampson.
Senator Sampson votes yes.
Senator Sampson has voted yes. Representative Sims.
Representative Sims votes in the affirmative.
Representative Sims votes in the affirmative. Representative Veach.
Representative Veach votes yes.
Can you please repeat?
Yes, Representative Veach votes yes.
Perfect. Thank you so much. Representative Walker.
Representative Walker votes yes.
Representative Walker has voted yes. Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Thank you, Madam Administrator. Folks, that concludes our agenda for today. As noted previously, the votes will be held open until 5 o'clock for members to get their votes recorded. I want to thank everyone for their cooperation and participation as we've moved quite a bit of product, and particularly some big and important bills over the last 2 days as we kick off this JF week in the Judiciary Committee. We are going to cancel tomorrow's meeting, so the Judiciary Committee will not meet tomorrow. that will give leadership of the committee as well as the LCO attorneys the opportunity to refine language for Thursday. We expect another beefy agenda on Thursday, and then do expect to meet on JF Day on Friday as well. So we'll take tomorrow as a little bit of break, and we will see everybody back on Thursday. I believe our meeting is scheduled to start at 9. Our meeting is scheduled to start at noon, but expect caucuses, around 9:30, as we've had the last couple of days on Thursday. Questions, comments from my co-chair, the ranking member?
No, sir.
If not, we will stand in recess until 5 o'clock. Thank you all.
Madam Administrator, I think I have a vote.
I beat you, Harding.
Okay, so okay.
Sam Sampson beat me. I'll give him that. I'll give him.
Okay, Senator Sampson, let's
Pretty sure I just missed one, the first one.
I know you missed the first one. Let's just double check though. Senator Sampson, how do you care to vote on number 1, Senate Bill 888 with JFS language? That was cannabis. JFS post subsidy LCO number 6457. How do you care to vote?
Senator Sampson votes no.
Senator Sampson has voted no. Let me just let Rosa back into the meeting. Okay, let me just double check, make sure we've got everything. Okay, you are all set. Thank you, Senator Sampson.
Thank you so much, Deb, and thank you, Stephen and everyone else. Take it easy, guys.
My pleasure. Good evening, Senator. Have a good night.
Okay, Representative Harding, let's see if he's missed anything. Yes, you have. The item number 4, 6355, an act concerning risk protection orders or warrants. That was the JFS proposed substitute LCO number 6462. Representative Harding, how do you care to vote?
Representative Harding votes yes.
Representative Harding has voted yes. Okay. Are you sure?
Yep.
Okay, that's fine.
No, I understand why you asked.
No, I just want to make sure you know we're built around.
I do appreciate that, man.
Yeah, misery loves company there, Steve.
Oh, goodness. Let's see what else we got. And I think we voted on this one. Yep, you're all set, Representative Harding. Thank you.
Thank you, Deb. Have a good evening.
You as well. Okay, who else would like to go next?
If I Deb, I was just seeing, oh, sorry.
I have a telehealth appointment at 4 o'clock, so I'm sorry to.
No, go for it.
Representative Curry. Okay, the first one, Representative Curry, enact 888, enact responsibly and equitably regulating adult use cannabis, JFS proposed subsidy LCO number 6457. Representative Curry, how do you care to vote?
Representative Curry votes yes.
Representative Curry has voted yes. Let's just double check real quick. Item number 4, 6355, an act concerning risk protection orders or warrants, JFS plus subsidy LCO number 6462. Representative Curry, how do you care to vote?
Representative votes yes. Yes.
Curry has voted yes. Okay, voted on that one. Okay, I'm pretty sure. All set. Thank you so much.
Thank you very much. Have a good night, everyone.
You as well. Thank you.
Bye, Jeff.
Okay, who's
Deb,
next?
I don't, this is Rep Gilchrist. I don't think I missed any, but could you check for me? Because I was kind of in and out all day.
Absolutely. You're all set. Thank you.
Thank you so much. Have a good one.
You as well. Representative Bimbis, Bob, do you mind waiting till ladies go first?
Absolutely not.
I believe Representative Godfrey was before me.
No, go ahead, Representative. My mother wouldn't like it any other way.
You have a smart mom.
Yeah, she was great.
Okay, Representative Bimbis, item number 4, 6355, and concerning risk protection orders or warrants, JFS plus subsidy LCO number 6462. Representative Bimbis, how do you care to vote?
Representative Bimbis votes no.
Representative Bimbis has voted no. Item number 8, enact 6548, enact with the recommendations of the jury selection task force, JFS proposed substitute LCO number 6173. How do you care to vote?
Representative Bimbis votes no.
Bimbis votes no on that. Okay, all set. Thank you so much.
Thank you, Deb, and
Thank
thank
you. We'll see
you,
you
Representative
Thursday.
Godfrey.
Take care.
All righty, Representative Godfrey, let's see. If you've missed
I may
any.
have missed one relatively early on.
Yeah, item number 4, now concerning risk protection orders or warrants, JFS proposed substitute LCL 6462. How do you care to vote?
Representative Godfrey votes yes.
Representative Godfrey has voted yes. Let's just double check while you're here. Cool, and you voted, I'm positive that you voted aye, but it doesn't hurt to check. You are all set.
Thank you very much. Enjoy your day.
You as well. We'll see you on Thursday.
Madam Administrator?
Hello, Senator Lesser. Let's just check what you got here.
I may have gotten everything, but just double checking.
Yeah, no, I appreciate it. Double check, I'm pretty sure you were right. Yeah, like I said, yeah, you're all set. Thank you.
Wonderful. Thank you so much.
Bye-bye now.
Yeah, this is Pavlok D'Amato. I was wondering if, I think I might have missed one towards the end.
Let's see. Go down the list for all I've got you here and double check. Yes, you're right. Item number 7, last one before the consent calendar. 6539, the enactment, well, it was enactment concerning the Creighton study, JFS proposed substitute LCO number 6368. Representative Pavlok D'Amato, how do you care to vote?
That was HB 6539, right?
Yes, that would, they took the, it was a strike all amendment for the commercial driver's license holders and pretrial alcohol education programs and made it a Creighton study.
Creighton?
Yeah, Creighton's, I guess, some new thing that the kids are using to get high.
Okay.
Do you want me to send you the substitute language?
I can find it.
Okay.
I will, Pavlok D'Amato votes yes.
Okay. I'm pretty sure everybody, with the exception of Senator Sampson, voted yes on that, if it makes you feel any better.
Yes, thank you.
You're welcome.
Have a good day.
You as well, thank you. Hello, Representative Walker. Thank you for joining us.
All right, okay, hold on. I'll be right back. I gotta vote again. I'm sorry. I'm doing too many things at one time.
What a surprise. What a surprise, you know?
Yeah.
Oh my goodness, I don't know how people who run committees do it. Anyways,
Okay.
Item number 1, 888, cannabis with the substitute language.
Yes. Representative Walker votes in the affirmative.
Representative Walker votes in the affirmative. Thank you. Item number 4, 6355, enact concerning risk protection orders or warrants, JFS proposed substitute LCO number 6462. Representative Walker, how do you care to vote?
Ooh, what was this, number 2?
Number 4 was the second one we voted on, but it was item number 4, enact concerning risk protection orders or warrants, had substitute language.
Was the substitute, I'm sorry.
No, I'm just saying all the Ds voted for, pretty much all the Rs against it.
Okay, I'm a yes.
Okay. Could you say
Representative Walker votes in the affirmative?
Thank you, Representative Walker. Okay, item number 8. Enact concerning 548. Enact concerning the recommendations of the jury selection task force.
Yes.
Representative Walker, it was amended. You want to vote for that? Yes.
Representative Walker votes in the affirmative.
Okay, thank you. Item number 3, enact concerning civilian police review board, security guards, body worn recording equipment, and searches by police, JFS with Amendment A. Representative Walker, how do you care to vote? Everybody voted for it except with Senator Winfield, Representative Doucette, Senator Flexer, and Representative Sims. Everybody else.
I'm so I was okay. Representative Walker is in the negative.
Okay,
Yeah, I remember that, and that's why I said, ooh.
yeah, okay. And then you voted for that one, and you did, I'm pretty sure you voted for the consent calendar. Yep,
Yep.
you're all set, off the hook.
Thank
On
you,
to the
thank
next.
you.
Thank
Bye-bye.
you.
Bye-bye.
Hello, Representative Riley.
Hi Deb, how are you? I believe
Good.
all I have to vote on is the consent calendar.
Let's just double check. Well, I got to here. Yep, you're absolutely right. Representative Riley, how do you, want me to read off the consent calendar for you?
No, I have it here. Thank you.
Already.
Representative Riley votes yes on the consent calendar.
Perfect. Thank you so much, Representative Riley. You're all set.
Thank you, Deb. Have a good evening.
Good. Now, I don't know if you heard that we're not going to be in tomorrow. We're going to be in on Thursday.
Oh, okay. Thank you very much.
You're welcome.
Have a good
Take
night.
care. You as well. Bye-bye.
If we have straight voice over IP, we should be able to.
Deb,
Representative Labriola, yes. Okay, let's see what's back here.
just the consent calendar, I think.
You sure? You want me to just double check? I'm pretty sure you were here. You were here for most of the time, so I'm just gonna look through just to make sure. Good. Yep.
Okay, as to the consent calendar, Representative Labriola votes yes.
Representative Labriola votes yes. Thank you so much. And I don't know if you heard me tell Representative Riley, there's no meeting tomorrow. We'll meet on Thursday at 12 o'clock.
12 o'clock. Okay, beautiful. Thanks a lot.
Thank you. Bye-bye now.
Bye.
See you on Thursday. Okay, so I'm going to go ahead and record these actions because I know people are hot on these bills.
Okay, do you want me to take any? I can take items. I can take the first 5 if you want.
Hold on, 1, 2, 3, 4, 5. Yeah, but it only leaves me with 2.
Okay, do you want me to take the first? I can take the first 3 that we actually did.
Okay, take the first 3 and I'll do the rest.
Okay, how many does that leave you?
I've got, I'm not worried. I mean, it's better than last night. Last night I don't know, for some reason, I just could not get the system to cooperate. But
I know
whatever.
it doesn't matter.
Okay, so
you want to just send me, you want to just send me pictures?
Yeah, I'll send them to you right now and then you can start them and then you can just, as you're listening in, just add to them.
Okay.
Okay.
All right.
Alrighty, so I'll go ahead and start doing that. I'm just gonna get something to drink and I'll be right back.
Okay, sounds good.
Hi.
Hello.
Hi. Sorry for being a little late. So
You're here before 5 o'clock, so that's all okay. Go ahead, and I see Representative Luxembourg there too. So let's just get Senator Anwar because I don't think he has as many. Okay, Senator Anwar.
Thank you.
shuffled them around here.
Deb, is it okay if I find out what was the vote count for 888?
Sure, so far, let's see. Okay, it's so far yay 19, nay 16. We're waiting for 3 Democrats to vote.
Okay, I've already voted nay on that.
Yes.
Okay. Number 2 is 938.
Number 2, we held number, we held number 2.
Okay, we held that.
Yeah, we held that one. Number 3, let's see, that was 1093. Not concerning civilian police review board, security guards, body worn camera equipment, and searches by police. It was a JFS with an amendment offered by Representative Fishbein, seconded by Representative Staffstrom. Senator Anwar, how do you care to vote?
On the amendment?
No, you can't vote on the amendment because it was a voice vote. I just wanted to explain to you that the bill was amended.
Yeah, okay. Yeah. So 1093, the amendment had failed, right?
The amendment passed.
The amendment had passed.
That is correct.
Okay, all right. Do you know if the votes were around party lines?
No, the votes, almost everyone voted for the bill. We had 1, 2, 3, 4, 5 negative votes. Those were Democrats, but the rest of the Democrats and the rest of and all the Republicans voted for the bill.
1093 is a yes.
Okay. Could you please say Senator Anwar says
1093 is a yes.
right, but Senator Anwar
Senator Anwar votes yes on 1093.
Thank you so much. I'm sorry to be so picky, but
it's okay. Good.
Okay. Item number 7. Item number 7. 6539, and that concerning commercial driver's license holders and pretrial alcohol education programs. There was a strike all amendment, strike all language, JFS code substitute LCO 6360, which turns it into a CRATOM study. And everybody has voted on the bill affirmatively with the exception of Senator Sampson. Senator Anwar, how do you care to vote?
Senator Anwar votes yes on 6539.
Thank you. 6539. Okay. Put it on that one. Item number 8. 6548, and that concerning the recommendations of the Jury Selection Task Force, JFS proposed substitute LCO number 6173. Senator Anwar, how do you care to vote?
Senator Anwar votes yes on 6548.
Thank you, Senator Anwar. Okay, and you voted on the consent calendar, so you're good.
Okay, thank you so much. Did I vote on 6665?
665. Let's see here. If that was restricted up this one. Hold on. Good point. Where is that?
That's number 9.
Yeah. Why don't I have it here in front of me? Maybe I just with another piece of paper.
Sorry, Jeff. Sorry.
No worries. I'm just.
No rush, Senator. No worries.
I just don't know if I disconnected my little mess here. It's kind of crazy. Oh, he's here in the house.
We are good?
Maybe I brought it with me. Hold on one moment. Let me just see if I brought it with me in the kitchen.
Okay.
Thank you for checking on that. Now I just have to locate where it went. Oh, jeepers. Sitting right here. Of course, it was on the consent calendar.
6665 was
I
on the consent.
apologize. It's on the consent calendar, and you've already voted on the consent calendar.
Okay, thank you. I voted yes on that. Thank you so
You
much.
did. Yes, thank you.
Thank you. Thank you, Representative Luxembourg, for your patience. Thank you, Zoe, for your help.
No problem. Have a great day.
Thank you.
Goodness gracious, I'm losing my mind. Okay. Hello, Representative Luxembourg. Welcome.
Good afternoon.
Good afternoon. Let's start at the top. Representative Luxembourg, item number 1888. That's the cannabis bill.
Yes.
Amended by 6457. Would you care to vote on
Representative
this?
Luxembourg votes yes.
Representative Luxembourg has voted yes. Item number 3, 1093, not concerning civilian police review board, security guards, body worn recording equipment, and searches by police, JFS with amendment A. Representative
Luxembourg votes. Luxembourg votes.
You keep cutting out when the vote part comes.
Luxembourg votes yes.
Luxembourg votes yes. Third time's a charm. Excellent. Okay. Item number 4, 6355, an act concerning risk protection orders or warrants, JFS for substitute LCO number 6462. Representative Luxembourg, how do you care to vote?
Luxembourg votes yes.
Luxembourg has voted yes. Okay. Item number 7, 6539, that was amended by JFS post substitute LCO 6368, which is a strike all amendment. So now it's a Kratom study. Representative Luxembourg, how do you care to vote?
Luxembourg, yes.
Luxembourg has voted yes. Let me just let Representative Porter in. Okay. Item number 8, 6548, an act concerning the recommendations of the jury selection task force as amended by LCO 6173. Representative Luxembourg, how do you care to vote?
Luxembourg votes yes.
Okay, and then the consent calendar, we already know 6665 is on there, and then 6491, which is the lethal, non-lethal electronic defense weapons as amended by proposed substitute LCO 6454 and 6665, the removal of restricted covenants based on race and elimination of the race definition on marriage licenses, JFS proposed substitute LCO number 6369. How do you care to vote on the consent calendar, Representative Luxembourg?
Luxembourg votes an emphatic yes.
Emphatic yes. There you go. See, you condensed the whole day's business in not even 5 minutes, 3 minutes. Very efficient.
Thank you very much to the committee for accommodating me. Appreciate
Well,
it.
no worries. And just one more thing. We have canceled tomorrow's committee meeting, so we'll be on Thursday, 12 o'clock.
See you Thursday.
Okay, thank you.
Bye, Representative Porter.
Hey, Deb.
Hi, Representative Porter. But we can just a second. I just got to tell the bulletin clerk to Meeting tomorrow is canceled. I just wanted to let them know because they're going crazy because we were late sending in the notice. Okay, I'm sorry to keep you waiting.
That's okay.
So I don't know if you've heard, but the meeting tomorrow has been canceled, so it's going to be on Thursday at noon time instead of tomorrow. So tomorrow you're out.
Okay.
All righty. So item number 1, Representative Porter, Senate Bill 888, as amended by the proposed substitute LCO 6457. That's cannabis. How do you care to vote, Representative Porter?
Representative Porter votes affirmative.
Representative Porter has voted in the affirmative. Okay, item number 2 is held. Item number 3, an act concerning civilian police review boards, security guards, body worn recording equipment, and searches by police as amended by an amendment A. Representative Porter, how do you care to vote?
I'm sorry, Deb. I was getting in the car. Can you tell me what it was? An act concerning?
An act concerning civilian police review boards, security guards, body worn recording equipment, and searches by police.
Representative Porter votes in the affirmative.
Representative Porter has voted in the affirmative. Okay. Item number 4, 6355, an act concerning risk protection orders or warrants as amended by proposed substitute LCO number 6462. Representative Porter, how do you care to vote?
Representative Porter votes in the affirmative.
Representative Porter has voted in the affirmative. Item number 7, 6539, which was an act concerning commercial driver's license holders and pretrial alcohol education programs as a strike all amendment that has made it a Cray-Tom study. Representative, everyone voted yes. It's brand new, but everyone voted yes except for Senator Sampson. Representative Porter, how do you care to vote?
Representative Porter votes in the affirmative.
Representative Porter has voted in the affirmative. Okay, item number 8, 6548, an act concerning the recommendations of the Jury Selection Task Force as amended by proposed substitute LCO 6173. Representative Porter, how do you care to vote?
Representative Porter votes in the affirmative.
Representative Porter has voted in the affirmative. We've got 2 bills on the consent calendar. 6491, which is the non-lethal electronic defense weapons, as amended by proposed substitute LCO 6454, and item number 9, 6665, an act concerning the removal of restrictive covenants based on race and elimination of the race designation on marriage licenses, JFS proposed substitute LCO 6369. Representative Porter, how do you care to vote?
Representative Porter votes in the affirmative.
On the consent calendar. Excellent. Okay, that's it. Well set.
There was a bill, I don't think you called it. Maybe you did and I missed it. I think it's 1093.
1093. Hold on.
We had a few people that voted no on the bill, including Chairman Winfield.
1093. Yep, 1093. That was, yep, I wrote, yep, that was an act concerning civilian police review boards, security guards, body worn recording equipment, and searches by police. Yes, some people did vote no on that bill.
Okay, that one I wanted to vote no on that.
Okay, that's fine. We can change that. No worries.
And that's SB 1093, correct?
Right. So can you say Representative Porter votes no on 1093?
Yes, Representative Porter votes no on Senate Bill 1093.
Okay, great. Thank you.
Thank you. Bye-bye.
Bye-bye. Now you heard, okay, so we'll see you on Thursday.
Yes, at noon you said, right?
Noon on Thursday. Yep. Thank you.
All right. Thank you.
Bye-bye now. Have a good
Bye-bye.
day.
You too.
All righty, so let's see here. Let me start from the beginning. So I think the only one we're waiting for right now left is Senator Bradley.
Okay.
Oh,
So do you
Senator Haskell has missed a few votes.
Oh, I think he just signed on.
Senator Haskell? Yeah, there you are.
Let me just.
I'll ask him to unmute you, but maybe he's in another meeting. I'll send along pictures meanwhile.
Okay, so 888, 1093, and 6355. And then you can send me another one.
Okay, so let's start with this. Let me just stand up here. My sugar scratcher. Okay, what's the other one you wanted, 1093 too?
Yep, 888, 1093, 6355, and then you can send me another one.
Okay.
Hey Zoe,
There he
are
is.
votes still open?
Yes, they are. Hello.
Oh, hey Deb, how are you?
That's all right, Senator. We're doing good. Okay.
I just got my shot. So I'm very excited.
Congratulations.
Congratulations.
Thank you, thank you.
That's the first one?
Yeah, just the first one.
Yeah. We've all heard the stories about the second one being worse, but today, finally on the Today Show, not finally on the Today Show, but I heard today the reason why the younger people have more of a problem with the second one is because they're younger and their immune systems are stronger. So it's their immune system that's rebelling against the thing. Whereas like old people like me, we could take 25 of those and keep healing.
You're not old, Deb. You're not old.
Yeah, well, I'm older than you are. But it's all good. It's all good.
Too.
Let's see where we're at. And I see Senator Bradley has joined too. So we'll get through Senator Haskell first. Okay, Senator Haskell, item number 3, 1093, Civilian Police Review Board, Security Guards, Body Worn Reporting Equipment purchased by police, JFS with A, Amendment A. Senator Haskell, how do you care to vote?
Senator Haskell votes yes.
Senator
And
Haskell?
the amendment was a voice vote, is that right?
Yes, that it was a voice vote, yes.
Wonderful. Yes, I'll vote yes.
Okay. All righty. And you voted for item number 4. Item number 7 is 6539, enact concerning commercial driver's license holders and pretrial alcohol education programs. There was a strike all amendment, proposed substitute LCO 6368, which made that bill a Kratom study.
Yes, Senator Haskell votes yes.
Senator Haskell voted yes. Okay, item number 8, 6548, enact concerning recommendations of the jury selection task force. And that was amended by, go ahead.
Oh, I'm sorry. Was it amended by voice vote?
No, it was amended by proposed substitute LCO 6173. I've mailed all these to you, but if you need them again, I can remail them.
No, that's okay. I saw it and I'd like to vote yes.
Okay. Can you say Senator Haskell?
Oh, I'm so sorry. Senator Haskell votes yes.
Thank you, Senator Haskell. All righty, and then the consent calendar you did not vote on. The consent calendar had 2 items. Item number 5, 6491, enact concerning non-lethal electronic defense weapons as amended by post substitute LCO 6454 and 6665. The removal of restrictive covenants based on race and elimination of race designation on marriage licenses as amended by proposed substitute LCO number 6369. How would you care to vote on the consent calendar, Senator Haskell?
Senator Haskell votes yes on the consent calendar.
Senator Haskell voted yes on the consent calendar. Wonderful. Now, and you saw that, I don't know if you heard that we're going to be off tomorrow.
Yes, I saw that. That's good to hear. Thank you.
Sounds good. Okay, we'll see you on Thursday at noontime.
Wonderful. And did I miss any? I know I can't make up for it, but just out of curiosity, were there any roll call amendment votes that I missed, or no? They were all friendly amendments.
They were just the one voice vote. I believe it was just one, like one voice vote. I think just one amendment today. The rest are all.
Perfect. Thank you so much, Deb. I really appreciate it. See you on the day after tomorrow, I guess.
Sounds good. Thank you.
Bye-bye.
Senator Bradley. There you are.
Hey, how you doing, Deb? Nice to see you.
Very well.
Yep, here I am.
Wonderful. Okay, item number 1, 888, cannabis. There was a proposed substitute LCO 6457. Senator Bradley, how do you care to vote?
What's the tally of it, Deb, if you don't mind me asking? Where are we now?
Okay, let me add it again because we had some few more votes. Okay, 21 to 16.
21 to 16 in favor, I'm assuming.
That's
all right,
correct.
I'll vote. Senator Bradley votes in the affirmative with strong reservations, but I'll vote in the affirmative.
Okay, Senator Bradley has voted in the affirmative. Okay, item number 3, 1093, not concerning civilian police review board, security guards, body worn recording equipment and searches by police. That was a JFS with Amendment A, which was an amendment that was offered by Representative Fishbein and seconded by Representative Staffstrom. It was passed by a voice vote.
I'll vote in the affirmative. Senator Bradley votes in the affirmative for both. I'm sorry, we have to take one at a time, right? So is I vote in the affirmative for the amendment and for the underlying the bill.
Okay, the other one was
Senator Bradley votes for the bill.
Now, item number 4, 6355, and concerning risk protection orders or warrants, proposed substitute LCO number 6462. Representative Bradley, how do you care to vote? Excuse me, Senator Bradley.
Senator Bradley votes in the affirmative.
Thank you, Senator Bradley.
Senator Bradley votes in the affirmative.
Item number 7, 6539, and concerning commercial driver's license holders and pretrial alcohol education programs. There was a proposed substitute LCO 2368, which struck everything on that bill, and it is now a Kratom study. Senator Bradley, how do you care to vote?
Oh, so now it's a study as opposed to an actual bill?
Yes, that is correct. It's a Kratom study.
Well, I guess Senator Bradley votes in the affirmative. Disappointed in that, but it is what it is.
Yeah, everyone else voted in the affirmative with the exception of Senator Sampson.
Right. Well, studies, you know how that goes, Debbie, but that's above my pay grade.
Thank you, Senator, for voting. Item number 8 and 6548, and concerning the recommendations of the jury selection task force as amended by proposed substitute LCO number 6173. Senator Bradley, how do you care to vote?
Senator Bradley votes in the affirmative.
Senator Bradley has voted in the affirmative. There was 2 items on the consent calendar. Item number 56491, enact concerning non-lethal electronic defense weapons as amended by proposed substitute LCO 6454, and item number 96665, enact concerning the removal of restrictive covenants based on race and elimination of the race designation on marriage licenses as amended by proposed substitute LCO number 6369. Those are the 2 items on the consent calendar. How do you care to vote, Senator Bradley?
Senator Bradley votes in the affirmative.
Senator Bradley has voted in the affirmative. Wonderful. Okay, we are all set.
Debbie, thank you so much for your time and your patience with all of us. Thank you.
Yeah, no worries. And you heard that we're going to be in on Thursday, but not tomorrow.
Heard that. Yep. Thank you. Well deserved
Okay.
R&R. Yep. You too. Take it easy.
Take care. Bye-bye now. Okay, so we are, we can start putting these votes in. Hey Zoe, I just realized I didn't give you the second page of the amendment on 1093.
Okay, I'll wait.
I'm sending it right now.
Okay, thank you. Sorry, I'm just trying to figure out my printer is not cooperating today, of course, the day that I need it.
Everybody has the same problem. I mean, I shouldn't say everybody, but I think it's just the connection between.
I know. And then I keep disconnecting and then reconnecting. And then I just tried to add it and it's not there. So I'm like, and then I tried to scan it, but I can't scan it unless I connect. It's fine.
All good. All good. All good. Yeah, Alan was having the same problem the other day, and so was George. So it's like, whatever. Yeah, reason I'm happy I don't have a printer is I don't have to deal with this. I just deal with the office.
I know, this is such a pain. And then it's offering all the printers at work, but I'm not there. So it's not really helpful.
Okay.
Deb, Senator Bradley and Haskell both voted yes for the Creighton study. You're muted, but I'm assuming that's a yes. It's okay.
I'm sorry.
It's okay.
Yep. Creighton study. Yep.
Okay.
Yep.
All right.
Yep. Yep.
Thank you.
Oh my goodness. Somebody's asking me all the tax ramifications of 888.
Oh,
Sharing amendments.
we can't do that right now.
And they have a deadline today.
That's unfortunate. It's very unfortunate.
I have deadlines too. I'm gonna do it. That's my deadline. Oh God.
You just sent me those 4, right?
Yes.
Okay. All right. Just to make sure.
1, 2, 3, 4. Yep.
And everyone was here except for Senator Kissel, right?
Yep.
Okay.
Be easy.
5 o'clock, Deb. Just wanted to let you know.
Oh, yeah, thank you. I've got involved here. 5:01. Judiciary Committee meeting is now over. See you on Thursday. Bye, y'all. Thank you for your attention.